But may I have liberty to mention a matter? Lordship, this was regarding that state commission forum. There was no quorum. Lordship permitted me to go and file a transfer application.
Yes, yes.
I have been trying to do that. There's one technical difficulty. There is one e-Jagriti portal which does not recognize any order except the state commission's order which directs transfer. So the High Court's order which permitted me to make the transfer application and go there, my lord, and move it before the principal bench because that bench was not there. My lord, I really could not do it despite my best efforts.
But mention before the presiding officer
My lord,
there.
now it's everything. It's mentioned also before the presiding, my lord, officer.
Because that technical problem can be taken care of by the.
They cannot deal with the technical issue at all. My lord, the wherewithal is not there, my lord. That's the whole difficulty, my lord. They say, we also contacted, my lord, e-Jagriti portal there. We tried to convince them that this is an order of High Court. You have to work out so that this matter can be transferred. My lord, no help from there also. We contacted the help desk of e-Jagriti portal. There also we did not get any response.
All right. Let it appear under the heading. You have filed any application?
No, my lord. I want that the civil revision was directed to be listed 3 weeks hence.
Oh.
My lord, next week, any day, my lord, if it can come, I will apprise your lordship what is the situation.
Lordship, may I mention one matter? On 26 June, my matter was dismissed when my matter was not even listed to be called on that day. Lordship, item number 827 of the monthly list.
Item number
827 of the monthly list was supposed to be called. Your Lordship.
Yes.
I have
item number 80 monthly study.
Your Lordship, I have annexed all.
Your monthly list is 1493.
The item number is 1493. That is 1764 of 2025. Item number 827. That is CO 1764 of 2024. Item number 827 was listed on that date and the same was called.
2024.
Yes, sir.
এই 1493 ফাইলটা কোথায়? সে ফাইলটা আছে তো?
This is the date fixed in the trial court, Your Lordship. As of
Tomorrow it will appear under the.
To mention a matter, my lord. My lord, it was taken up earlier, but my lord, the learned senior counsel was busy in another court that we have prayed for a Passover, my lord. And my lord, after that, the matter has not appeared, my lord, and the eviction date is fixed on 5th July, my lord.
Next Wednesday.
My lord, I have mentioned earlier 2 dates, my lord. The eviction date is 5th July, my lord.
Since you have paid for Passover, it can't.
My lord, kindly, my lord.
It's another one matter. It's for listing and urgent hearing. The
Not today. Next. Come on
urgency
next.
is that
Come next Wednesday.
Lordship, my lord, may I? Urgency is that there is an imminent threat of dispossession on 4th this month, 4th July 2025. On or after 4th
What
July
is the impugned order
2025.
you are challenging?
Impugned order I'm challenging. It's an order passed by the district magistrate. It was passed to the DRT. DRT matter, my lord.
Yes.
Yes, at the time of filing of the revision application, the DRT was not in session. And
When
the
did you file the
DRT,
revision application?
in June, my lord. And my lord, while the DRT
What order was passed?
the DRT application was
No,
passed.
what order was passed in your civil revision application? You paid for an adjournment.
No, my lord.
It did not appear in the list. When
No,
have
my
you
lord.
filed?
I had no, my lord. I have no knowledge of that, my lord.
Please take instructions. Since when have you filed a civil revision application?
In June, as far as my instruction
So
is, my
it
lord.
appeared on the date you have mentioned in the presentation form. Please check up the what order has been passed. Yes, call the list.
Lordship, item number 215, your lordship. Lordship, the trial court next date is 8th of June, your lordship, for order.
8th of June.
July, your lordship.
For what?
For orders, your lordship.
Nothing.
Lordship, kindly.
Yes, call the list. Item number 1.
Lordship, I beg to appear on behalf of the opposite party.
Correction of the name of the learned advocate.
There are two
Name of the
typological
learned
errors.
advocate for the,
Petitioner as well as the opposite party.
Both
being
are
the same.
Das. That is the problem.
what is the,
And-
please give the correct name.
Correct.
Opposite
The-
party is correct. But the name of
Opposite
the-
party is correct.
correct.
Subhabrata Das and Arindam Banerjee.
Yes, it's correct.
And petitioner,
Petitioner, I was for the petitioner.
those
I am
the-
giving the name.
and please give the Mr. Das, only your name will be added.
Yes.
No junior.
No junior.
Acha.
Lordship, one
And opposite party is correct.
opposite party is correct.
Yes.
One more. In the cause title, it's Nomita Bosi. It will be Bose.
Oh. It has been pointed out that there is a typographical error.
Two Milord, Mr. Bhattacharya is appearing.
Praying for,
Mr. Bhattacharya, release.
since I'm not inclined to take up this.
My lord, I'm for the petitioner for the extension of interim order. The applications also have been filed, and these are the affidavit of service.
Interim order is still June. Why did you file an application?
It was abundant precaution, it was filed.
Abundant precaution. Application is liable to be dismissed. Have you seen the cost title? Name has not been correctly spelled. Cost title. Cost title is just after
Yes.
CO number and in the
Yes, yes.
matter of.
I have seen, my lord.
So it's rejected. Interim order should not be extended, Mr. Mukherjee.
My lord, I pray for correcting the cost title. Pray for. Yes, that's a valid ground for it. I
Yes, have you
apologize.
served? Who is for the other side?
I have served the revisional application on 30th April and the application on July. The affidavit of service, both the affidavit of services. will be taken on
Affidavits of service filed in court today is taken on record. First up as paid for by Mr. Mukherjee.
Petitioner, my lord. Matter relates to a club, my lord, affairs of a club, my lord, affiliated under the CAB, my lord. My lord, the
Affiliated under?
Cricket Association of Bengal, my lord. The matter is, my lord, also before the ombudsman also.
Since I'm not inclined to take up this matter,
Item 5, I'm for the item 5, I'm for the petitioner, my lord. This is my application for expeditious disposal of a matrimonial suit, my lord. The suit is currently at the stage of evidence of PW1. Previously, there was a miscase which has been disposed of, my lord. Alimony is being paid, my lord, and the suit was filed in the year.
this case has been disposed of.
Yes, my lord.
When?
2nd of May 2024. The order is also there, my lord.
2nd of May 2024.
2024, my lord. Kindly seize the order sheet, my lord. 2nd of May, the order number 15, dated 2nd of May 2024. It has already been recorded that she is getting rupees 10,000 in a proceeding under section 125, and in the miscase, it was directed I'll pay 3,000 and 1,500 per month.
This application under Article 227 of the Constitution of India.
Your Lordship.
Yes.
My lord, it isn't, I filed a title suit that has been dismissed, my lord, for default. Thereafter filed a miscellaneous case for restoration of the said suit, my lord. That has unfortunately been dismissed for default, my lord. It is a stranger purchaser property, my lord. We are the co-sharer, my lord. The persons, my lord, which defendant, one of the defendants are stranger purchasers.
What can be done? Suit dismissed for default. In this case, you did not participate rightly. Conduct is very bad.
And they are very poor person. I have pleaded that, my lord, to some, so that if it can be admitted and for continued application of
It speaks for show cause by the petitioners. So, directed to show cause as to why the miscellaneous case should not be dismissed for default.
No, that was on that the step was taken, my lord. Learned advocate somehow there was some emergency. He have left the court, my lord. Kindly come to the last order, my lord.
Order number 3,
Yes, my lord.
It says that received the case records, such and such, date was fixed. 8th of October, none appears, moves for the both of the sides. You are filing adjournment petition. It was rejected, directed to show cause. It was adjourned to 27th of November. 27th of November, the same was accepted. 31st of January, it was fixed for hearing ex parte. Then also on 31st of January, you did not move.
No, that was, my lord, kindly petitioner files Hazira along with prayer for time for filed in affidavit in chief.
Yes.
OB files on repeated calls, none appears, my
Yes.
lord. Yes,
At the time of call, you did not
No,
appear.
they
You have
did-
filed Hajira.
my lord, this,
You have filed Hajira. That's
my lord.
at the time of call, you have to appear. You have not appeared.
But somehow there is the personal difficulty of the advocate. He left the court. That's why he could not appear, my lord. If a chance can be given, my lord, I know that I
File an application. File an application for restoration of that miss case.
miss that with that liberty, my lord.
Because I cannot from here say what were the grounds for.
No, my lord, that's why I am not so much not beseeching to that extent, my lord, because I cannot improve my on record. I cannot improve my conduct, my lord. Only ground is that it is the stranger parts challenger court-divided court.
Sir, if you have a strong case on allowed the suit to be dismissed for default, miscellaneous.
That's why, my lord, that's why I am beseeching, my lord. My lord, I leave it to your lordship, my lord. I shall not.
By the order impugn the
I'm for the
Yes.
Union of India.
Yes.
My lord, we have been served only with this copy.
You are for the opposite party.
Yes, my lord.
What you have been served with?
Served
You have
with-
not lodged any caveat.
No, my lord.
Then
I'm for the Railways Authority.
I'm for the petitioner.
yes.
Only one thing, my lord, I'm paying for some adjournment because of the fact there are 4 writ petition and different order has been passed. Well, that at present is not with me. Those are
Mr. Das,
those are
adjournment, yes, that will be allowed, but don't pray for upgradation.
My lord, we have not been served with any copy also,
On the prayer of
my lord.
Mr. Learned.
Obliged.
Yes, next.
number 8.
I appear on behalf of the petitioner. I'm led by Miss Sen. She's on her legs before court 28.
Proceed, please proceed.
Praying for not today, my lord.
On the prayer of the learned.
Appear for the petitioner, my lord. This is my application for expeditious disposal of my mat suit, which was filed in 2015 in Bangalore. My petitioner resides in Bangalore. Second, then third, the wife filed an application for transfer of the suit before the order of the Supreme Court, and Supreme Court directed the matter to transfer in the Alipur Judges Court in 2015, specifically directing to dispose of the suit within next 9 months. In 2015, that order was passed. Now, my lord, due to various reasons, the opposite party, who is now getting, she is getting 10,000 rupees alimony per month on the ground that she has filed a review application before this order of court challenging an earlier order which was passed in favor of the petitioner. My lord, since 2015, my lord, the suit is pending. But the Supreme Court specifically directed that order I have also annexed.
Where is that order?
My lord, that is, lordship kindly come to page 25. the specific order, my lord, page 26, it starts from page 26. The second paragraph, my lord. The family court at Alipur Court, Kolkata, where the matter itself shall be decided within a period of next 9 months without rendering any undue adjournments to either of the parties. And my lord, we are in 2015. And now they are making delay in disposal of the suit, my lord. So I pray for my lord expeditious disposal of the suit, my lord. And cross-examination of the petitioner just started, my lord.
Who filed order 6 Rule 17?
My lord, that is another application. The name of change the name of the surname of the opposite party from Mondal to Rai Chaudhary. My lord, that is not under challenge, my lord.
The learned
For the petitioner in this matter, I'm led by Mr. Aurik Banerjee. He is appearing virtually, my lord.
The caveat opposite party.
My lord, I believe Mr. Banerjee is somehow unavailable. May I move the petition then, my lord?
Yes.
My lord, this is my civil revision preferred from the order dated 11th of June 2025, which your lordship will find at page 18 of the petition, my lord. What?
Who are you?
My lord, I am the defendant in the testamentary suit. I am the testator's daughter. The petitioner is the testator's son, grandson, my lord. My lord, I'll tell you, lordship, what has happened. While the cross-examination of the plaintiff was going on, the plaintiff himself, during construction work, two very important documents were discovered which directly have nexus to the sound mental and physical health of the testator, my lord. As and when the documents were discovered, without any delay, we have produced the same before the knowledge of the court, my lord. However, the same were rejected without any rhyme or reason. Page 32. Your
Where
lordship
is the
kindly-
proposed amendment?
My lord, the proposed amendment is at the application is at page 25 and the medical documents are at page 31 and 32.
25.
Schedule at 28.
My lord, my 3 points before the learned court was that I have shown due diligence because the same document was first of all a subsequent discovery and was not within the power and possession of me. It was locked and it was not within my knowledge. So as and when the same discovery was done, I have produced the same before the court. Second of all, it was merely formal in nature. The plaintiff is still in the witness box. The cross-examination is going on. No damage or prejudice would be caused to the plaintiff because he would still get
That
a
is your
chance.
written statement.
My lord, the written objection has not been annexed, my lord.
statement.
That has not been annexed, my lord. I have annexed my petition, their written objection to my petition and my reply to the same, my lord. And my notes of argument before the learned court is also there, my lord.
Madam, the important thing is the written statement. Judgments, written notes, those are not relevant. This is the only document which is to be annexed, and the application and the objection.
My lord, may I, with the
Because
leave
we
of
are
this
paying for amendment of a written statement, just to be seen. The written statement.
my lord, with the leave of this honorable court, may I file the same with the by way of a supplementary?
Yes, I have got a copy. Yes, Mr. Banerjee.
There may be some technical difficulty, my lord. If your lordship will kindly come to page 5 of my petition, my lord, at paragraph K, I have summarized. May I place the same before your lordship, my lord?
Yes, what do you want to place?
My lord, I want to place page 5 of my petition, my lord. My lord, I'm led by Mr. Banerjee. He's
I was appearing for the petitioner here. Sorry, I joined a bit late, your lordship. Your lordship has, my learned junior has placed the facts. It's a, probate application contested. I filed a written statement during the cross-examination of the plaintiff witness. Some documents have transferred which will have a material bearing in the case, and that will decide the real issue in controversy. Which are, your lordship, medical documents at page 31 and 32, which will show that the testator at the time of his death was not in sound, fit, and mental condition to execute a proper will. And this has transferred, your lordship, at the time of cross-examination of the plaintiff's witness. So we wanted to amend a written statement, taking this additional point that he was not in sound.
Yes, Mr. Anand Banerjee. Yes. Yes, Mr. Anand Banerjee.
My submission is, my lord, in the written statement, no case has been made out, although she says that I was in good relationship with the propounder, father. Relationship was good, but she was not aware of the mental condition. That is not believable.
But Mr. Banerjee, while granting a probate, what is the duty of the probate court? So the probate court has to observe or has to come to a finding that it is the last will executed by the testator in free mind. So, and the suspicious circumstances, those are to be excluded. Those are to be. So, if it is a case made out that the testator was suffering from some disease, so what would be the effect of that?
Examination is over. Cross of
Mr. Banerjee, it may be because the recent Supreme Court decision you have seen. So, proviso may not always be an absolute part. If
no, not an absolute part.
So, if the proposed amendment is necessary, because considering the fact that this is a probate proceeding, so the state of mind of the testator is important, and they have said that these documents they have come to the possession of during the cross-examination. So, proviso to that extent stands satisfied. So, did they say that in the application for amendment?
Others still have chance, your lordship. Still have chance, your lordship. Yes, your lordship. Application for amendment, I have said that. That is at page 25, your lordship. And they still have chance to cross-examine my witness. It is only the cross-examination of the plaintiff. I will give my chief, I will produce documents. He has a chance to cross-examine.
Between this period while the construction work was, so they have explained. Proviso, explanation has been given.
They have come into possession of the document subsequently. That
Yes.
may be the fact.
Yes.
But they have to show that there is no new case made out. One. And secondly, this new case.
Mr. Banerjee, this is a probate proceeding. Please keep that in mind.
Keeping that in
is
mind,
a
I'm
probate
submitting.
proceeding. So it's the duty of the court to find out that whether it was the last will, whether it was properly executed or not. That's the only duty of the probate court. So this is a fact which is relevant because they did not at that point of time come to the knowledge of these facts. So subsequently come. So
Not kindly come to the amendment application once. Page
yes,
58.
yes.
They have mentioned the diseases. These diseases have nothing to do with mental capacity.
That will be
That goes to the merits of the matter,
part
my
of the
lord.
amendment.
That veracity and authenticity cannot be
merits of
looked
the
into at this
amendment
stage.
cannot be considered, whether they will, whether this,
Whether it is necessary or not, that can be considered.
yes, necessary or not, they have said because of this. And audible, clear, the court has to consider with the effect of those.
Is it any mental disease? That is not at all anything related to mental disability.
But this is relevant. If I can show that he was not in fit health and sound condition, then the will goes.
At page 32,
Then there cannot be any proper execution of the
going
will.
to the document, only the averment.
No.
32 are the medical
He was
document.
having a mental ailment.
Documents cannot be looked into. The subparagraph will not go.
This can be looked into.
Subparagraph will of paragraph 5(7) will not go. Documents cannot go.
7 can be looked into. Now, whether or not these diseases
Only one thing.
relevant to assess the mental
Mr. Banerjee,
condition.
you are right that the evidence did not be pleaded. You are right. But now, if as per the amended civil procedure code, you have also to file the documents along with the plaints on which you are relying upon.
Right.
If that is so, this will become if allowed, this will become a part of the plaint. Why should not these documents also be allowed to be filed? It will be as a list of documents.
This is not the plaint. This is the amendment. They have annexed.
Yes, if allowed, it will form part of the plaint. So if original plaint, you have to file documents, why not with the amendment?
I am not saying he cannot file documents. I am saying, Lord, that I cannot look into, maybe not look into the documents because we cannot
That
go
will
into
be
the
considered at the time of trial.
But the averments in the amendment we can look into.
Yes.
From the averment, it does not appear that he was suffering from any disease which relates to mental ailment or mental incapacity. Number one, no averment. Then why is it necessary? He was having jaundice. He was having.
But the medical documents will show that
Mr.
he was suffering from mental illness.
Dense nuclear cataracts in both eyes with diminished vision.
No, that is not the amendment. The
Yes,
averment is that.
yes, amendment, averment.
No, this has to be read.
Suffering from diminished vision goes to the root of the execution. Ashun, this application.
Gratefully. Your Lordship, one judgment, Your Lordship knows 2006, these principles were plain. Amending a plaint is not applicable for it. Sorry, sir. Sorry,
Yes.
sir.
5(7) has to be read with 5(8).
Yes.
It does not say because of paucity of vision, lack of vision, he was in a incapacity to execute the will. It says he was not in a sound mind and with full knowledge.
Yes,
Now,
knowledge is there. Full knowledge is, if diminished vision, that goes to the knowledge.
now kindly come to the written statement once.
And on his own volition. So these are facts.
Kindly come to the written statement now, Millard. Page 10, paragraph
seen the
10.
written statement.
Paragraph 10,
There
what
is,
is the?
Mr. Banerjee, I have seen the written statement. There is no foundational basis of this.
No foundational basis. One.
I've seen that.
Second is, Millard, that their case is that this is a act of forgery. So they,
yes, that is a different thing.
Completely destructive. Millard. If they are saying that no will was executed, it's a forgery. Now they are saying it was executed.
From that.
And see what is the case made out. I have gone through the written statement. It is not mutually destructive. It cannot be allowed. If they are saying that it was forged, kindly see para 10. What is the case made out? It is further stated, para 10, page 6, last paragraph. It is further stated that any will and testament of Shamsundar Ghosh, since deceased, must have been forged, fabricated, manufactured by the applicant to enjoy entire property by depriving 50% legitimate shareholder. So it was never executed. That is the case. And now,
this is an additional ground. Defense can always be taken, Your Lordship.
Additional
defense once it is transferred. So additional ground, there is no bar in written statement. Even in a eviction suit, if filed on the ground of default of payment of rent, subsequently, if it has come to the knowledge that the property has been sublet, this can be an additional ground in an eviction suit. It does not change the nature and character of a suit. And written statement, the amendment principles are more liberal than a plaint.
Mental incapacity, state of mind of the testator means they are admitting that it was executed, but he was not in a frame of mind.
No, that we are not saying.
Yes, Mr. Banerjee, this is mutually destructive. Paragraph 10 and your proposed amendment.
Your Lordship, kindly see to that.
The allegation was that it was a forged. When you are saying forged, so you are saying that it was not executed. Now you are saying executed but not with free mind. This is mutually destructive.
I am saying that I have never said that the document has been executed. This is an additional.
Mr. Banerjee, amendment, the basic principle is amendment of written statement is more liberal. Court should construe it in a more liberal manner. So there are two riders to that. One is you cannot withdraw the admissions. Second is the proposed amendment cannot be mutually maybe consistent, but cannot be mutually destructive with the original pleadings. Paragraph 10 and the proposed amendments are mutually destructive to each other. This cannot be permitted. What is the reasoning given by the trial judge?
This
Court has given
is an additional ground which has come to our knowledge after the written statement has been filed when the cross-examination was going on.
Mr. Banerjee, one thing, the court did not consider, trial judge did not consider the merits. Trial judge went with the proviso. Proviso has been
no new set of facts. Second page, first two.
Reasoning given by the trial judge that I do not fall within the proviso, second proviso.
Court has not in so many terms used mutually destructive, but said new.
That have not exercised due diligence.
The effect of the new set of fact is that they are taking a
no new set of facts which cannot be permitted after trial is commenced. That's a different thing. So the court is only on the proviso. Court says new facts after the commencement may not be permissible. So the court did not consider. I am directing the trial court to reconsider that because it's only with the proviso.
Kindly record my submission that this is the ground which is to be considered, because we shall take the point there. But
Mr. Banerjee, if I am setting aside, it's better not to make any observations on the merits.
So only my submission that this ground is taken. Ground of mutual distraction, which is not taken.
That all points I will be keeping open. Do that.
There is only one judgment of the Honorable Supreme Court, which the latest LICI judgment also follows. That is 2006 SCC. It says that even if different
yes
in written statement it is taken, it can be.
Which paragraph of LIC? Paragraph 7.
The amendment principles are not strict.
And has passed.
No, this is paragraph 71 relies upon this judgment. Your Lordship will kindly consider this judgment, 2006 SCC.
Have been arrived at which subparagraph of paragraph 71 you are relying upon?
No, Your Lordship will kindly take up 2006 volume 6 first. Madhurima, kindly place 2006 volume 6 first. Your Lordship will kindly take this judgment first. This is on the written statement.
Yes.
Paragraph 9, 15 and 17.
Kindly take paragraph 15, Your Lordship, of this judgment.
Paragraph
15, Your Lordship, 15.
Yes.
Let us now take up the last ground on which as well as the trial court. The rejection was made on the ground that inconsistent plea cannot be allowed to be taken. We are unable to appreciate the ground of the rejection made by the High Court as well as by the trial court. After going through the pleadings and also the statements made in the application for amendment of written statement, we failed to understand how inconsistent plea could be said to have been taken by the appellants in their application for amendment, accepting the plea taken by the appellants in the application for amendment of written statement regarding the joint ownership. Accordingly, on facts, we are not satisfied that the application for amendment of written statement could be rejected also on this ground. That apart, it is now well settled that an amendment of plaint and amendment of written statement are not necessarily governed by exactly the same principle. It is true that some general principles are certainly common to both, but the rules that the plaintiff cannot be allowed to amend his pleading so as to alter materially or substitute his case of cause of action or the nature of his claim has necessarily no counterpart in law relating to amendment of written statement. Adding a new ground of defense or substituting or altering a defense does not raise the same problem as adding, altering or substituting a new cause of action. Accordingly, in case of amendment of written statement, the courts are inclined to be more liberal in allowing the amendment of written statement than plaint, and question of prejudice is less likely to operate with same rigor in the former than in the later case. This being the position, Your Lordship, therefore, the view that inconsistent pleas can be raised by the defendant's written statement, although same may not be permissible in the case of plaint. This principle has been enunciated in this court and clearly laid out that inconsistent or alternative pleas can be made in written statement. Accordingly, the High Court and the trial court has gone wrong in holding that defendants are allowed not to take it.
I have also said inconsistent can be taken, but not mutually destructive. This decision did not consider that. Where is the decision of mutually destructive pleadings cannot be taken? I have told you that inconsistent can be taken in written statement. That's a well settled proposition.
Lordship, this is an additional fact which has come to our knowledge.
But
After the filing of
additional,
written statement.
Mr. Banerjee, additional fact you can take, provided that is not mutually destructive.
Your Lordship, then let that the trial court decide after
Yes.
evidence, Your Lordship, if it is mutually destructive.
Now you want to cite the decisions of LIC. That is why
LIC is the latest judgment, Your Lordship.
Yes, yes.
71.
paragraph 71, it deals with some
Correct, correct.
conclusions.
Your Lordship has also delivered a latest judgment relying upon the LICI
Yes, yes.
on
Ashwin,
this issue.
application
Grateful,
Yes.
my lord.
Thank you. Yes, next.
Item number 11. My lord.
My lord, in item number 11, I am for the petitioner, my lord.
Yes.
My lord, this is a matter pertains to, my lord, expeditious disposal of a suit granting letter of administration. My lord, I have filed a suit in the year of 2015, my lord. In the year of 2021, my lord, the cross-examination of the plaintiff witness number 3 has been commenced.
27 of the Constitution of India is at the instant. First up, in view thereof, CO number such and such stands disposed of by requesting the learned additional district judge 11th court at Alipur to make an endeavor to dispose of OS number 10 of 2015 as expeditiously as possible without granting any unnecessary adjournments to either of the parties, keeping in mind that the suit is pending from the year 2015.
Grateful, my lord.
Well, Your Lordship, I'm for the petitioner, Lordship.
Yes.
Lordship, I'm praying for an expeditious disposal of an ejectment suit filed in February 2019, and it's been more than 6 years that it has been pending, and no meaningful progress has yet been made.
This application under Article 227 of the Constitution
So same not for expeditious disposal, but the fact remains that I have been directed to pay litigation cost per month 2,000, which I have been compliant with. But as per direction of this honorable court, but still
no order for alimony.
No order for alimony. Litigation cost per month. But anyway, I am complaining with the order. Suit is pending from 2018, and thereafter they have been paying for adjournments. Now the stage is that defense witness go over.
Witness is over.
He is also argument, but again, they have paid for time in the last occasions. So the
What is
next
the
date
date
is
fixed for argument?
The argument is not fixed, but they are praying for again to produce another defense witness or like that. But next date is 18/7. But they have been praying for adjournment from
18/7 fixed for what?
Fixed for further evidence, if any. That's my instruction.
Further evidence of defendant's witness.
If any, but wife examined full. Not my instruction is father
This
is
application under Article
some time in the
227 of the
Lordship, I am acting for the defendant petitioner, Lordship. Plaintiff file a suit for eviction.
What is the impugned order?
Section 7(1) and 7(2) are dismissed. Strike out the defense under section 7(3).
On what ground?
Ground the application file deleted after a period. After the 1 month period mentioned in the.
When did you file?
Lordship, that is not my case. Lordship, case is the suit is filed under TP Act. Lordship, kindly come to the plane.
Suit is filed under the TP Act.
Yes, Lordship. Leave and license agreement, Lordship. Page 9, Lordship. I annex the.
Then why did you file 7(2)?
So I cannot say.
You have filed 7(2).
Lordship, I know, Lordship. I filed the 7(2).
So
the Lordship, suit is TP Act, Lordship, page 9, plain. And also averment of the leave and license agreement. Defendant is sister of the plaintiff. Paragraph number 4, 5, and 6 also stated leave and license agreement after expiration of the time, not vacate, so that file this present suit. Specifically under TP Act lawsuit suit, section 7(1), 7(2), 7(3), not applicable in this suit.
what is the rent?
Lawsuit rent 14,000. 7,000 is a rent and 7,000 is a maintenance charge. Paragraph number 4, it was stated, lawsuit, plaintiff. Page 4, paragraph number 4, page 10, paragraph number 4. It also says that time was elapsed thereafter.
There is substance in the argument of the learned advocate for the petitioner that
For the petitioner. Lordship, this is also an expeditious disposal of an ejectment suit, Lordship, which was filed in 2019. 7172 filed in February 8, 2021. Lordship, if you could, Lordship would see the records. Several 10 to 12 adjournments have been taken lastly. Show cause was given and cost was given to the, but they are not appearing in the suit, Lordship, for which the
this application under Article 227 of
dispose of the 7-1 and 7-2.
7172, what is the date fixed for hearing?
The next date is not there, but the last examination was held in May 22, 2024.
No, the
Thereafter-
last order is 11th of July for PW1.
Yeah, 11th of July, yes, 11th of July for PW1, and before that, almost 8 days they have taken adjournment, Lordship. Last date, May 22, 2024, PW1 was examined. Thereafter, 8 days have passed.
Where is the order fixing for section 72? There is no order.
Order sheet, I think it's annexed.
Which order?
Oh, Lordship, the order sheet after 2023 is not there.
Then,
but so my instruction goes, Lordship.
Yes, next.
Item number 16.
Under the petitioner's amendment of written statement was rejected. So, my kindly, I kindly come to my original written statement. Running page 29 starts. So, on my lord, this is on paragraph 8 onwards, my lord, running page 30, wherein I have stated that the opposite party landlady is not my inducted landlady because she has not inducted me. She has subsequent transfer. She has purchased the property, but without giving any letter of abandonment. The landlord tenant relationship was.
Give me a minute. Give me a minute. Where is your written statement?
No, my lord, this running page 29, my lord. It comes relevant page, my lord, page number 30 on paragraph 8 onwards, my lord. Page 30, paragraph 8 onwards, my lord. That in reply to the statements made in paragraph 1 of the plaint, the defendant stated that the plaintiff has not stated anything about acquisition of title in the suit property. Even no document of title has been stated nor forwarded any copy of such document to the defendants, for which the defendants are unable to make any further comment, and hence crave leave to file additional written statement after receiving the copy of the said document. The defendants say that the plaintiff is completely stranger to them. Thus, the plaintiff has made vague statement of ownership of the suit property. Even the previous owners never served letter of adjournment to the defendants intimating the transfer of the right, title, and interest. Further, the defendants were never asked to pay rent to the plaintiff either by the previous owners or by the plaintiff. That in reply to the statement made in paragraph 2 and 3 of the plaint, the defendants say that the father of Sanjit Kumar Das and Vishwanath Das originally inducted Saumar Mondal, since deceased, the husband of the defendant number 1 and the father of the defendant 2 as tenant. And after the demise of Saumar Mondal, the defendants legal heirs became the joint tenants, and after death of the father, said Sanjit Kumar Das and Vishwanath became landlord of the defendant, collected rent time to time. That the entire statement in paragraph 4 of the plaint are absolutely false, frivolous, and concocted, malafide, and denied. It is stated that the previous owner landlords never intimated any kind of transfer of the suit property in favor of the plaintiff. The entire thing is based on surmise and conjecture. So, my lord, kindly come to my amendment applications, my lord.
Yes.
It starts from my lord. My lord, kindly come to I have annexed the title deed by which the opposite party has purchased the property. So, kindly come to running page 42. There is a list of tenants on which the property has been purchased by the opposite party along with the tenants. The name of the tenant show that my name is not in the deed. So, kindly come to running page 42 and 43, my lord. This is the deed by which the opposite party has purchased the property, my lord. There is a list of tenants. He has purchased the property along with the tenants. There are the names of tenants wherein my name is not disclosing. It's a huge, big property he has purchased. I am at small 80 square feet tile shed rooms. I am in tenant. So kindly come to running page 42, my lord. It is the deed. It's the last paragraph. Whereas the vendor absolutely seized and possessed of the others well and sufficiently entitled to the land and premises with the said kacha pakka structure standing therein, fully occupied by the tenants, namely Vishwanath Mondol, Lokshinaram De, Povitra Kumar De. All of the 4 tenants, they have purchased the property. Even the deed annexed to the plan of the deed does not show the demarcation of my tenant premises. Kindly come to my amendment applications, my lord. This is running page 62.
The question that arises for
This is same matter, my lord. Same matter.
contested application. Next of same 17 same order. Next the suitor number to boli thi.
Number 18.
Title suit, ejectment suit number will be different, my lord.
Ejectment suit number to suit state.
If I may, Lordship.
Yes.
Lordship, if I may, in respect of item number 15, Lordship, your Lordship opined that the order sheet of 7172 is missing, but it's there in the end. I failed to show it during that time, Lordship.
Please wait. Yes. Who is item number 18? Who is for the petitioner? None appears for the petitioner at the time of call. No accommodation has been.
Interim order stands vacated.
If the main proceeding is dismissed for default, interim order will remain. That's the law.
Next. Item number 19.
My lord, I appear for the petitioner. My lord has had occasion.
I beg to appear on behalf of the private respondent. I am the claimant before the Facilitation Council. My lord, the subject matter of challenge is an order under section 16 of the Arbitration Act.
Yes,
my lord,
we do not serve them.
My lord, I am not on caveat. My lord, I was praying, let a copy be served. And my lord,
My lord, may remember the point involved. I had argued this before your lordship on the
Yes,
last
yes.
occasion.
At that point of time, they were not there.
No, there was no caveat, so we had not. Very well, if my lord so desires, I will serve them.
My lord, the test is now high. It is either bad faith or the party having no remedy, or my lord, lack of.
Suppose you are challenging the jurisdiction.
Yes, jurisdiction. I'm saying, as on the date of entering of the contract, he did not have the requisite registration certificate granted under the Act. And on the last occasion, the matter was adjourned because my lord was wanting
to bring the contract. When the contract was entered into.
to get yes, to bring the contract. Now, my lord, there was no formal contract as such, but we should show your lordship from the papers that bills were raised, my lord, based on that letter of intent. And above all, we should show your lordship, my lord, judgments to show that a letter of intent can also very well, my lord, be taken and read as a contract if parties have decided.
So, yes, when do you want?
My lord, any day, my lord, Monday, if your lordship permits.
When this matter is taken up for hearing, the
Mr. Jonathan.
I'm for the petitioner, my lord. My lord, come up against my lord, a rejection under my lord, order 7, rule 11, my lord. I'm the defendant in the suit.
Before my land significant starts, my lord, I want to indicate there is a maintainability point that I would be raising, my lord, in this civil division.
Maintainability of the civil division application.
No, is locus standi.
Locus standi.
Locus standi of for what?
Of the blood, as on this day, this entity, JM Financial Asset Reconstruction Company, is no longer entitled to, my lord, recover any claim from the Abhinandan Holdings. My lord. So, my lord,
No, I'm the defendant in the suit.
That is on merits.
I'm saying, Lordship will hear me for 2 minutes. I'll submit, my lord. Abhinandan Holding had filed a suit against JM Financial. For a specific.
Where is the plaint? Where is the plaint?
So the plaint is at page 131.
131.
It's challenging, my lord, a termination of an assignment agreement. The assignment agreement, my lord, has, my lord,
yes, Abhinandan filed against JM Financial and against JM Financial.
Yes, I'm the only defendant. I filed an application.
JM Financial and Howrah Mills.
Yes.
Yes, Mr. Ghosh. What is your point of demurrer?
My point, well, his point of
Not the in the civil application.
I have to say that first.
That is, your learned junior was trying to take that point.
Sir,
first.
it's a
If according to you, you will take that after Mr. Banerjee makes his submission.
I'll take that thereafter.
He said that is to be, you should be allowed to make that point first.
Yes, yes. Very well. There is a point below. There's a limited life of the trust. Below, it's the period under
Life
the
of trust.
Well,
it's a company.
Below, it's a reserve bank. Below, has published the notification. There's a period for that. That period is.
So let me hear Mr. Banerjee.
Well, I'm a defendant in a
Mr.
suit.
Banerjee, how long you will take?
I'll take some time.
Estimate how long?
Well, at least,
Conservative estimate.
half an hour to 45 minutes.
Yes.
Half an hour, my lord. Have you got all the cases?
Yes, Mr. Banerjee.
Lord, kindly come to my lord, the plaint at page 131. Sorry, my lord. Before that, may I, my lord, show my lord, the assignment agreement which
Can you take me to the impugned order first?
Yes. That is, my lord, at page 517.
The certified copy is there 14th of February 2025. Order dated 14th of February.
Yes, my lord.
So your application under order 7 rule 11 stood rejected.
Yes. I took, my lord, I'll just, my lord, briefly also indicate what the points. My lord, this is a plaint filed by Abhinandan, who, my lord, there was an agreement to assign, my lord, a debt of, my lord, Howrah Mills. To, my lord, Abhinandan. I am, my lord, the creditor of, my lord, Howrah Mills. In the agreement to assign, my lord, there were certain, my lord, payments which had to be made, my lord, in a time-based manner. They made the first payment, thereafter, my lord, they did not make payment. I terminated the agreement to assign. And my lord, I've been proceeding, my lord, in the section 7, though I'm still, my lord, not yet to get my order there, my lord, against Howrah Mills, but I'm proceeding there. They filed a suit challenging that termination of the assignment agreement. This is, my lord, the subject matter of the suit. I filed an order 7 to 11.
What are the grounds there?
My lord, first ground, my lord, taken, my lord, it is filed as a commercial suit. My lord, first ground taken, my lord, was
12A.
12A. First ground taken section 12A because they filed after 18 months, my lord, of the termination notice, my lord, being issued.
This is after that judgment or prior to that judgment?
That after part in, before part. Before part.
So that bar will apply, I think, after in suits filed after that.
Yes, Mala, that's what it says. The judgment says so, Mala, from the particular date, Mala, this is a 2021 suit.
So from the date of the delivery of judgment after suits filed after, so it has to be, I think that's the language of.
Yes, Mala, that was one of the grounds taken. Then Mala,
Section 12A is one of the ground.
One of the grounds. Second, Mala, we also took a ground, Mala, that the assignment agreement itself has, Mala, a territorial exclusive jurisdiction clause in Mumbai. And there are decisions, Mala, I don't know whether we are.
Jurisdiction Mumbai.
Yes. Exclusive jurisdiction clause Mumbai. Our ground has been, Mala, that by reason of the exclusive jurisdiction clause, anything arising out of the assignment agreement really has to go there. And my offices, Mala, are in Mumbai.
Your office is at Mumbai?
In Mumbai.
And their office here,
Their office here.
Howrah Mills here.
Yeah, Howrah Mills here. They say the termination according to them. They say it relates to land, therefore it's a suit for land. I'll show that's not the case. If you're challenging an termination of an assignment agreement, it can't be a suit relating to land because it's the assignment agreement. Thirdly, we say that there's no cause of action with regard to the fact that a termination can't be really challenged in a suit for. There can't be a specific performance of the assignment agreement. That's what we have a Supreme Court judgment on that, pearl light really.
Yes. So there is no cause of action.
Yes.
But the plaintiff fails to disclose a cause of action.
Yes, plaintiff failed to disclose a cause of action. Correct.
Yes.
So no, those are the 3 grounds on which.
These are the 3 points of.
Correct.
Yes.
Now, kindly look at the assignment agreement, which is at page 44.
Yes.
Volume 1.
Yes. Yes.
Agreement to assign made this 15th day of January 2020. JM Financial Asset Reconstruction Company Limited. So the first part. Then 46 will find an Abhinandan Holdings Private Limited. Then for definition, borrower will see Howrah Mills Company Limited, to whom financial assistance was extended by Federal Bank. The predecessor interest in intending person and the financing document includes any person who was created. Then last line of that, the said loan account was subsequently assigned by the bank to JM FARC registered assignment agreement dated March 30, 2016. Then financial assets means more particularly described in Schedule 1, never below sunset. Then financing documents, purchase consideration. Then 47. Sorry.
These are the terms. So we need to go to the jurisdiction clause.
Yes, just kind before that, purchase consideration is 26 crore being the aggregate purchase consideration. Page 46 itself.
Yes, purchase consideration.
Let's see 7.4.2 of this agreement. Since paid 25%, 6.50. After that, they did not make any payment.
Yes.
Then whereas the intending assigner has expressed desire to acquire is agreeable to acquire the said financial assets. Parties are desirous of setting forth the terms and conditions. Then paragraph 2A, the assignment is recorded. Then paragraph 2C, the parties irrevocably and unconditionally agree that on or before March 25, 2020, subject to cure period as clause 7.4, intending assignee should make the payment as I mentioned clause 1.D above, and the party shall enter into deed of assignment. So this is an agreement to assign, and the party shall enter into a deed of assignment. This is very important because party shall enter into a deed of assignment.
So this is a sort of MOU.
Yes, it's an agreement to assign.
Sort of MOU.
Correct. Only when you make payment of the whole money, then only the question comes of entering into the assignment agreement. And this is very important.
The suit is for specific performance.
No, but I've terminated. One of the prayers is challenging that termination.
One declaration sought for that the agreement is valid, binding. That declaration also sought for.
Yes. 154. That's second volume. Second volume.
This is the difficulty. Plain in 2 volumes.
153, Lordship.
Yes, we are.
Plain in 2 volumes.
Yes.
But in first volume, the rest in the second volume.
Because of the pages 1.
There's a practice direction. This much pages should be in 1 volume. This much pages should. Lordship will make it. If it's a continuation, then that
to be done because that has to be done.
The advocate
Otherwise,
nowadays have nothing to do. Department will not accept.
It should be 150 or conveniently or whatever.
The last
Or-
page
or-
of the document, continuation of the document.
Well, yes, well, specific performance also there. Perpetual injunction.
Specific performance is there.
Yes.
So if that was not there, you have an additional ground of under Order 7, Rule 11.
Yes. But my lord,
That is why I asked you whether there is a prayer for specific performance or not.
Who knows this field better?
Yes.
But yes, my lord, in fact, my lord, if
So which relief you are placing? Mr. Banerjee, which relief you are placing?
no, I'm not, I'm just showing my lord what are the reliefs.
Yes. Specific performance, perpetual injunction.
Yes. Prayer be above perpetual injunction is defendant's answers, claiming under defendant bond acting in breach of negative covenant more fully in paragraph 25. Sum of 750 alternative decree for
Cancellation of the letters. I
Money
think this is the letter of cancellation of the
correct,
agreement.
Correct, correct.
And also that the forfeiture clause in that letter should not
Should
be
not be given.
given
So,
effect to.
what I'm on, my lord, is the fact that this is an agreement to
And mandatory injunction is to register a deed of assignment.
yes.
So when the prayer for specific performance is there, what is the necessity for again a mandatory injunction?
Lord, I think by
Like, if it was not, it would have been barred. If the additional prayer is not,
Is it necessary, however valued, according to mandatory injunction or specific performance of
they have
contract?
given the full court fees. It filed after giving full court fees.
No, however valued, according to specific performance
Yeah,
or
it's
mandatory injunction?
Well, let him, I do not want to interrupt like that. Willard, it's Willard for the suit is valued at 11.5.
specific performance, declaration, injunction, other reliefs. That's all it says.
So valued as of specific performance.
Kind will take page 100.
Because mandatory injunction, you can give your own valuation.
It's, kindly take the valuation statement at 153, para 48.
Yes. Yes, Mr. Banerjee.
So, my lord, what I'm my lord, on and which is very important, that my lord, this
So
agreement.
please show me that in the agreement that jurisdiction
Yes,
clause.
that's my lord, page 49. I'm aware of it. I just don't. Let's say it.
49,
Page 49, my lord, 7.2.
7.2, governing law and jurisdiction.
This agreement shall be governed by and construed according to the laws of India. Any disputes arising pursuant to, out of, or under this agreement shall be submitted to the exclusive jurisdiction of courts tribunals in Mumbai.
Yes.
Then 7.4, my lord, performance, page 50.
7.4. Yes.
So 7.
Performance.
Yes.
So this has nothing to do with Order 7, Rule 11.
No, I'm showing, my lord, the nature of the agreement is it's an agreement to assign because they have taken one of the grounds saying it's a suit for land.
Yes.
This is not the assignment agreement.
Yes.
They're saying it relates to property, therefore it is a suit for land.
So
they are saying, no, sorry, this is an agreement to assign.
the first thing is that it is to be decided whether it's a suit for land or suit for performance of an.
Correct. If it's a suit for land, then perhaps, my lord, there may be something, my lord, to say on that. If it is a, otherwise, my lord, the exclusive jurisdiction clause.
What is the court held? Trial judge held?
Suit, my lord, suit for kindly, my lord. Yes. On that ground,
for land.
my lord, so far as the
So-
jurisdiction point is concerned,
Yes, please show me the impugned order with.
I can't decide. It's, my lord, page 5. At the last, at the end, as my lord, it is. 517 to 530.
Internal page of the judgment, which page?
I'll just skip that, my lord. It's at 520, internal page, my lord.
Please
10,
refer.
internal page 10, it starts.
10. Oh, jurisdiction is at 12.
At 12. Page 528 also. this, my lord, finding is not correct. Mixed question of law and fact, because, my lord, the jurisdiction clause is otherwise, if the suit is tried, my lord, where is the question of, my lord, then taking a jurisdiction point?
Mr. Banerjee, even if it is accepted,
yes,
this jurisdiction point, plaint cannot be rejected, it has to be returned.
Yes. Yes.
So it cannot be a ground under order 7
far as-
rule 11.
So far as
It can be a ground under order 7 rule 10.
10.
So that cannot be a ground for rejection, maybe for return.
For return. But rejection in the sense, my lord, because this court will not have jurisdiction, my lord, really to.
Has to be returned then. So,
So far as jurisdiction ground is
710 comes in case of jurisdiction, not 711. Because there is a specific provision.
Cases, my lord, if my lord looks at, my lord, order 7 rule
10,
11 also.
Yes. Barred by law.
Yes.
And if you come to 710.
Yes, my lord.
When there is a specific provision, so with regard to this jurisdiction, Mr. Banerjee, there may be two things. One is, if you say that the civil courts do not have, or the commercial courts do not have jurisdiction, it's one thing. Or we can take it as civil courts. You may say no, jurisdiction is with the tribunal or any other authority. Civil courts jurisdiction is expressly barred. Then perhaps order 7 rule
11 will come.
But if it's the civil court has jurisdiction, but may not be the court at commercial court at Calcutta, commercial court at anywhere else. I think subject to correction 710 will be the appropriate.
710, my lord, of course, my lord, that is subject to provision rule 10 and a plaintiff shall at any
Return to be presented to the court in which the suit would have been instituted. So that's your ground.
Lord,
So
I've taken several points, so this is one of the grounds.
Yes.
Therefore, my lord, 12A, my lord, could not have been under order 7 rule 10.
No, if on other grounds plaintiff is rejected, you need not press this.
But
So if you succeed on the other ground, then if you succeed on the jurisdiction, it should be order 7 rule 10.
Yes.
Yes.
Then, my lord, kindly. So, my lord, that's the clause. Now, my lord, coming back to the agreement once more, and that's very important because, my lord, at page 44, my lord, which I was showing.
The finding of the court is this jurisdiction is a mixed question of law and fact. So it cannot be decided under order 7 rule 11. That's
But, my lord, then, my lord, that defeats the whole purpose of, my lord, having a jurisdiction clause. If it goes through trial, then where's the question of having a jurisdiction clause?
Yes, so your submission is that jurisdiction has to be decided at the threshold.
Yes. Either, my lord, court has jurisdiction to decide or it doesn't have jurisdiction to decide. If you do not decide jurisdiction, you can't say jurisdiction on the question is a mixed question of law and fact when there's an exclusive forum selection because you're dragging me to trial contrary to what the parties have agreed.
Yes. Now you want me to see the agreement?
Yes, well, just once more, just kindly look at this assignment, page 47. And kindly note, 2C, very important.
Yes. Enter into a deed of assignment.
Yes. So this is, as the heading says at 44, this is an agreement to assign.
44.
Page 44, that's where the
caption may not be that important.
I'm just showing that.
To the
2.C, 2C is to show what this is.
Yes, yes.
In fact, NCLAT has also held it's an agreement to assign.
Yes.
You have the judgment. Because what happened, so they had paid 6.5 crores, the first initial payment, and thereafter they did not pay. Therefore, we cancelled it. The termination, will also find this. The termination page.
So
page 58.
This is with regard to the jurisdiction. Now you are coming to failure to disclose cause of action.
Failure to disclose cause of action.
Yes.
Before that, page 58. That's one of the termination.
Termination letter.
Yes.
Yes.
Lord, kindly see, subject agreement to assign. We refer to the agreement to assign dated January 15, entered into between GM Financial Asset Reconstruction and Abhinandan for assignment of outstanding debt of Howrah Mills Limited to Abhinandan and a letter bearing reference number such. As per the said agreement to assign, the said installment of the total purchase consideration was due and payable on January 31, 2020, subject to cure period of 30 days from due date. Abhinandan holders defaulted in making the payment of the due date, and after and also during cure period, which amounts to event of default as per the terms of the agreement.
Hereby revoke and cancel the agreement to assign and forfeits the amount.
Yes.
So for these two prayers, that not to give any effect to the
cancellation
and not to forfeit.
Not to forfeit.
Yes.
And also, they want a special performance of
the
that.
performance of that.
Lord, just wanted to show, I'll just show this. Now, Lord, kindly come back to. No, just show over the finding where it says. I'm sorry, I'm just trying to forgot the way the finding. Just give me 1 minute. Well, Lord, what had happened, Lord, I just wanted to show that judgment. I'll come back to the plaint. Well, Lord, they had used this suit to go and Lord, stall the Section 7 of IBC against Howrah Mills to say because this is pending, therefore you cannot proceed against Howrah Mills so far as the debt is concerned. Now, in that context, initially the Section 7 was dismissed. Then we went up to the NCLAT, the appellate authority, and also affirmed by the Honorable Supreme Court later, where they held that no, this suit doesn't stop. There was an order which was passed in the suit, injunction, that doesn't stop the Section 7 proceedings. And in that context, it was held that this is really an agreement to assign. So how much? Also because it's between the same parties, where there were also parties. So that
the Honorable Supreme Court has held that it's
the NCLAT has held. Then the appeal, because that's an appeal, it's not a special petition. Appeal from that was dismissed. So that will also have some relevance.
That's not SLP.
No, not SLP. Well, under the Insolvency and Bankruptcy Code, it's an appeal.
It's an appeal.
It's an appeal. Like from National Commission, they go up
yes.
in appeal, it's a similar provision to that. Now, I'll just show that also. Now, page 1 to the plaint.
Yes.
But kindly,
Banerjee, can you give me 5 minutes?
Yes. Lord, I have something fixed at 12:30. Can we?
I'm coming after 5 minutes. Important. Yes.
Your Lordship, sorry to interrupt the proceeding. Your Lordship, I'm for the item number 18. So sorry, couldn't reach the court in time.
Madam, this is not the time for mentioning. It's the
Your Lordship, I'm not mentioning. Let me finish. The learned advocate for the petitioner, he couldn't reach the court since his wife is.
Him to appear.
Your Lordship, please kindly. His wife needs immediate visit to the doctor since she's a patient of pituitary tumor.
Item number 18.
Your Lordship,
Yes, sir.
dismiss for.
Restore করে দিন। Yes, yes, Mr. Manager. Yes.
Well, in connection with this, we'll also have a look at this order of the NCLHE. And Supreme Court. Well, this is better to do.
Which page?
Just kindly look at how it arose. This appeal filed by the financial creditor has been challenged, ordered it passed by the Sunsage, rejecting section 7 are filed by the appellant financial creditor, agree by the order section, the financial filed this appeal. We had filed this appeal.
Yes.
Then kindly come to paragraph page 4. Page 4, just however, in the middle of the page, we'll see appellant filed, sorry, at the top, appellant filed a reply and such. Adjourning authority, after hearing the party impugner rejected section 7 application filed by the appellant, adjourning authority held that the appellant cannot proceed against HON'BLE Company Limited. However, it can proceed against respondent number 2 for any default. Respondent 2 was my learned friend here, this Obhinandan. Default committee respond to.
Yes, paragraph 12, page 13, clause number 1. This is what we are trying to refer to.
Yes.
Yes.
Page 7, it starts.
Yes, I've seen that.
I've seen that. Page
So
7.
the ultimate conclusion is that it's not an assignment agreement, rather it was an agreement.
Correct, correct. Page number 13, paragraph 12.
Yes.
Yes. So this went up. So and has read the 12.1.
Yes.
2 and 3 also.
Yes.
3 also. Further clause 2C, Sunsage contemplates party shall enter into a deed of assignment. Assignment is does by agreement to assign, taken by the has not stepped in the shoes of financial creditor, mainly by agreement to assign.
Yes. So this has been affirmed in this.
I'll just give that. Then the order also ordering portion in sees, then we were allowed to permit to proceed with the section. In fact, the section 7 was directed to be admitted against HON'BLE. That's
the difference.
Yes, we are still struggling with that, but then.
Yes. Yes.
So it's an appeal.
Appeal dismissed.
Appeal dismissed.
And so the order is on the findings according to you are binding. Binding
because Abhinandan is also a party to the
inter-parties.
Correct.
Yes.
Correct. Now, kindly look at the other judgments on the exclusive jurisdiction clause. Hakam Singh Dawade. Here, will of course remember the paragraph 4 of that judgment.
This is for what proposition?
This is for the purpose that if there's an exclusive jurisdiction clause.
Oh, this is on jurisdiction.
Yes. Because I'm still on the first the jurisdiction point.
Yes, yes.
Paragraph 4.
Paragraph 4.
We'll find code entirely applies to proceedings under the arbitration standard. Clause 13, then last 5 lines. But where 2 courts or more have under the Code of Civil Jurisdiction try a suit or proceeding an agreement between parties, dispute between them shall be tried in one of such court, not contrary to public policy, such as does not contravene section 28 of the Contract Act. This was what was in the judgment. We'll find refers to section 28 in impugned order.
So if it is to try a suit of proceeding an agreement based on an agreement.
Yes.
Yes.
My lord, because this is one of the questions, my lord, has been raised in the impugned order. In the impugned order, this is what the learned my lord judge says. Rather, it is to ascertain whether the conferring of exclusive territorial jurisdiction courts in Mumbai.
Which page?
My lord, internal page 12 of the order.
Yes.
Impugned order. My lord,
Yes, yes.
Where my lord, he was deciding the jurisdiction clause, the last 3 lines.
Yes.
Ascertain whether the conferring exclusive jurisdiction courts in Mumbai has divested this court to try the suit due to lack of territorial jurisdiction, or whether such conferring of exclusive jurisdiction of the courts in Mumbai has been violative of the provision section 20 of the Indian contract or not. So this is not a question, my lord, which is not, this is my lord now res integra. My lord, it is now decided. Because my lord, on the question of why I'm taking the jurisdiction point first, is my lord, if the court doesn't have jurisdiction, then my lord, the question of also deciding that it should be rejected on ground that does not disclose a cause of action will be my lord exercise of jurisdiction.
So according to you, the jurisdiction point is to be decided first, thereafter the other issues.
Yes, because otherwise, my lord, it
would not have entered into the other points of Order 7, Rule 11.
Correct. Because otherwise, my lord, it will be exercise of jurisdiction to determine that.
So, Mr. Banerjee, I think you have to argue only on the point of jurisdiction. Let me hear them.
Very well, my lord, I will show my
I
lord the
think
other
that's
judge-
better.
Very
So, if I find no, the commercial court at
I will
Calcutta,
then my lord come immediately. My lord, just give me the other judge.
it's a case of return of claim.
Yes.
Then there.
My lord, then my lord, the original my lord, you recall my lord, that was ABC laminate.
Yes.
You know, my lord, 1989 two Supreme Court cases 163. and 18.
Paragraph 16 and 18.
Yes, my lord. Eight, my lord, the paragraph 8 question is raised. Then, my lord, paragraphs 16 and 18. This is, my lord, following, my lord, that Hakam Singh, the original one, my lord, which on the first, my lord, it decided this issue. My lord, and paragraph 21, here, my lord, our clause, of course, my lord, is using the word exclusive also. Court said even if it's not exclusive, then also a forum selection clause will oust the jurisdiction of the court.
Paragraph
21.
Yes. It's the last sentence: when certain jurisdiction is specified in a contract and intention to exclude all others from its operation may in such cases be inferred.
Yes.
Even if those exclusive only.
It is
those
not that, then also. Mulad, now, Mulad, we have really, Mulad, come to that. Mulad, the last, Mulad, I'm sorry, Mulad, the swastik, Mulad, I'm sorry, Mulad, this we have a, I don't know why, Mulad, they got a Manu print. Mulad, we'll give the SCC.
Yes, please.
On
Yes,
that. Mulad,
that's.
I'll just, Mulad, supply, Mulad, with the.
What is the SCC reference?
Mulad, it is 20, no.
2013 9 SCC.
2013, yes, 2013 9 SCC, page 32.
Yes, paragraph.
Well, here paragraph 16 and 11, sorry, Mulad, first paragraph 11 jurisdiction clause there. Here, Mulad, there was a Calcutta exclusive jurisdiction clause. The section 11, Mulad, was filed, Mulad, in Rajasthan. In that context, Mulad, the paragraph 16, ABC laminate is considered. The other cases considered, and then uh, 28, sorry, not 28. Uh, 28 also discusses that. Then 31. 30 and 31.
I think last 4-5 lines of paragraph 31.
Yes. Where the court specific jurisdiction is concerned.
Yes. Prior to that, a legal maxim has been said.
And Mulad, just local
it has
judgment.
been held that such clause is neither forbidden by law nor against public policy.
Correct.
And does not also offend section 20.
And Mulad, Justice local judgment also there, 60, paragraph 62. Justice Lokur agreed, and Mulad also gave Mulad additional reasons.
That is, even if alone only exclusive is not used.
Yes. Mulad, it's a three-judge bench, Mulad, I find.
Yes.
Now, Mulad, in my, and quite naturally, Mulad, I had to make a order 7, rule 11, because Mulad, I had those other grounds as well. And this point, Mulad,
if you wish to make arguments in totality, you are also.
So, Mulad, I think the jurisdiction clause, because Mulad, like I said, Mulad, if the jurisdiction I succeed, then Mulad, exercise, it will be really an exercise of jurisdiction. If Mulad was to dismiss it, Mulad, on the ground of either 12A or Mulad on the ground of no cause of action.
So, according to you, if the court lacks jurisdiction,
yes,
could not have entered into the merits of the.
Correct.
The real problem is because we have clubbed both these things.
One had to, Mulad, because you have Mulad asked for dismissal.
You could have also prayed for return of.
I can't, Mulad, guide Mulad what they do. In fact, Mulad remembers last time, Mulad, I suffered, Mulad, because of Mulad that issue, Mulad, so far as Mulad the civil revision is concerned. So that had come up, Mulad, from the other order, Mulad, which was really termed as an extension, Mulad. 151.
You have not affected. We are not affected by that. Though we have to challenge those, but I have not really gone into that.
No, correct.
I have not gone into those.
Mulad held, Mulad, because we came, Mulad, because they had termed it as 151.
Yes, that's a
right. That's right. That's
so not that you have not challenged all the orders. That anything more, Mr. Banerjee?
No, that those are my.
Yes,
because Mulad, the main purpose, Mulad, of course, my purpose is, Mulad, to have my section 7, which Mulad now with the NCLAT order, Mulad, that's been, Mulad, permitted. So, Mulad, those are my submission, Mulad, on the
with regard to the jurisdiction.
On the question of jurisdiction, it should really, Mulad, go.
Yes, Mr. Ghosh.
Mulad, may I take my Lord's leave, Mulad? Just call me. I'll just come and do that and come. Please take notes.
Well, it's a order 7 rule 11 case, not a order 7 rule 10. It's not a order 7 rule 10 case. Lordship will find from the order, Millard, impugned order. What is the main thrust of argument was, Millard, 12A, bar under 12. So that was main thrust decided as an offshoot, Millard. This was argued. Now, Millard, for the purpose of order 7 rule 11, Millard, or order 7 rule 10, whatever is the case, the contents of my plaint has to be taken as true and correct.
Nothing more than
At
that.
least, Millard, before this court, Millard, I am confident to say. And Millard, whatever, Millard, interpretation, if you have to go, it's a mixed question of law and fact. If you have to interpret my suit, the way I frame the suit in question, it's a framing of the suit Lordship has to see. In a order 7 rule 11, in a Millard order 14 case or final hearing case, Millard, these are different, Millard. All points can be taken. But Millard, order 7 rule 11 is very strict, and only my plaint and nothing my plaint can be looked in. Even, Millard, there are two types of cases, Millard. Case A, Millard, is only the plaint, not even the documents. Case B, Millard, plaint and the documents annexed to the plaint.
So now the latest view is plaint with the documents.
And Millard, more latest is only plaint. Lordship can take it from me. I proceed plaint with the document.
There are two views.
One
Millard, says
we are, Millard, in the learning curve, Millard, on every day, Millard. When I came, Millard, preemption law was something different. Today, after 22 years or 23 years, it's completely changed. Similarly, with Millard, the position with Millard, adverse position. It has completely changed. So, Millard, kindly, Millard, look at the frame of my suit in question. Millard, kindly have a look at the plaint, which, Millard, starts at page 131. I'm very sorry if your Lordship wants, I can, Millard. Page, Millard, 131. Yes, the plaint starts. It runs into 2 volumes. It's better I give, Millard, 1 volume, because that's all, Millard, we have to scan.
Yes, 131. Yes.
Yes. That's, Millard, Obinandan.
Yes.
Is a company in Bidden Street. Millard, JM Financial is in Maharashtra within office in, Millard, 6 Russell Street. Howrah Mill is in Foreshore Road, Howrah. There is a agreement, assignment agreement or agreement to assign. So, Millard, I am asking for specific performance of that agreement. Now, Millard, payments have been made under that agreement itself. The agreement discloses on the body a financial asset. What is the object of the agreement? That, Millard, Federal Bank, Millard, has given, Millard, this particular entity, Millard, of some kind of assignment which has a trustee on the board. There is a trust under the Millard trust, Millard. The trust has a lifespan, Millard, which is itself has gone. That's different. I'll come on the jurisdiction last, because I want to argue on the merits first. Millard, Reserve Bank says, Millard, there's a Reserve Bank guideline, Millard, if you want to take some assignment.
So one thing, because Mr. Banerjee has not argued on the merits.
Very well.
He has restricted on the jurisdiction.
Because Lordship will hear me on his maintainability. Because I, Millard, kept it for last. Millard, that I answer, Millard, here and now. There are one case of Supreme Court.
Please proceed on the jurisdiction.
On the suit for
thereafter, if both of you want, because I have not heard Mr. Banerjee.
On his jurisdiction, Lordship will hear me. Because whether he can today maintain this action, this order, this Millard, challenge to my plaint at all, Millard, on the basis
that you can argue, and thereafter you please argue on the jurisdiction of
the caption is very well. I go, Millard, the first principles. The caption is suit for specific performance, declaration, injunction, relief valued at rupees 11.50 crores. So, Millard, normally what we know, Millard, in a suit for injunction, Millard, it has to be, Millard, suit for specific performance, or an injunction against a property has to be filed where the property is situated. Now, the question is, Millard, what happens to the forum selection clause then? Should I fall back to the contract between the parties on the basis of Hakam Singh? Or, Millard, I have to file, Millard, the safest option where the property is situated. It's no one's case, Millard. The property is not within the ambit of the commercial court at Rajarhat, which has a jurisdiction over the properties in Howrah in respect of commercial matters.
No, that's not. Mr. Banerjee's argument is that it's a suit based on an agreement. So
what has to be looked?
Yes.
My plaint.
And your case is that it's a suit based on, it's a suit for land.
Lordship, Lordship has to look at the frame of my suit. My argument or Mr. Banerjee's argument or Mr. Banerjee's defense or written statement immaterial. What NCLT says is immaterial. It can be an issue, Millard, in Millard, the order 14 stage. In the order 7 rule 11, Even Lordship knows the binding judgments between the parties authorities are not binding. Kindly have a look at the plaint in question. So my plaint is for specific performance, declaration, injunction, and other reliefs valued at rupees 11.50 crores. Now, Millard, kindly have a look at paragraph page para 3. The borrower company defendant number 2 is the owner of a jute mill situated at Howrah. The defendant number 2 has taken over the unit of the Howrah 1987 as part of the rehabilitation package under the BIFR scheme. Now, Millard, kindly straight away come. I'll not, Millard.
Mr. Mr. Ghosh, only one thing. Paragraph 3, second line.
Yes.
The defendant number which? It's blank.
It's really defendant number 2, Millard. It
should be defendant number 2.
Yes, yes. It has missed out. Now, Millard, kindly have a look at paragraph number.
Yes.
Paragraph number 4. The predecessor interest of the defendant number 1 along with State Bank of India had been the lenders who has made credit facilities in favor of the defendant number 2. The predecessor in interest of the defendant number 1 was in part consortium bankers headed by State Bank of India. In the month of January 2019, defendant number 1 filed an application under section 7 of the Insolvency Code against the defendant number 2 before the NCLT Kolkata, being number such and such, copy annexed. Under the agreement to assign, which was entered into between the plaintiff and the defendant number 1, that's para 6, the plaintiff had undertaken to take over the financial assets of the defendant number 2 from the defendant number 1. I stop here for a moment. What is the agreement? The plaintiff.
Sorry to interrupt, Your Lordship, but may I seek your leave, Your Lordship? May I seek your leave, Your Lordship? I'm so sorry to interrupt. My colleague is obliged to.
It's a pleading in the plaint. Under the agreement to assign, which was entered between the plaintiff and the defendant number 1, the plaintiff has undertaken to take over the financial assets from the defendant numbers 2 from the defendant number 1. So plaintiff will take over the financial assets of the defendant numbers 2 from the defendant number 1. The particulars of the financial assets have been mentioned in Schedule 1 of the agreement. Fixed charge and all the pieces of land, 95 kathas, such and such, Mouja, such and such, Shipur, municipal area, such and such, situated within the jurisdiction, referred in the suit property. Willard, if that be so, there's an agreement to take over, Willard, of financial assets, which, Willard, includes a immovable property in Howrah, which is pleaded in paragraph 6 of the plaint. Forget the schedule. I am on the body of the plaint. Is it a suit for land or not a suit for land? The agreement contemplates, Willard, taking over of the property by the plaintiff, the property of the defendant number 1 from the defendant number 2 from the defendant number 1. So, Willard, if the financial assets, I am on the body, if the financial assets describes this property, including the property, Willard, at Howrah, is it a suit for land or not a suit? Lordship has to go by my plaint, Willard, at paragraph. That's the reason with deepest or Willard, one can express, Willard, the language English is alien to us. Willard, one can express in 5 words, one can, I will take, Willard, 13 pages, my learned friends, Willard, take, Willard, 3 paragraphs. It's a question, Willard, what, Willard, the ultimately learned, Willard, trial judge said, in the teeth of, it should have been in the teeth of paragraph 6, could it be said, Willard, it's not a suit for land? Coupled with a prayer for injunction, specifically specific performance.
But the learned trial judge has not decided that issue.
It's not decided.
Because
main argument she got swayed was 12. Because this is what? Because that's the Willard easiest way to dismiss a suit. But Willard, the distinction before, which is recorded in the order with the name Willard, that Willard, it's recorded that Willard pre-Patil Willard suit cannot be dismissed. Because Patil, though Millard, the judgments are all retrospective in operation, Patil made it prospective. And this is clarified by the Dhanbad friends. The suit can only be kept in abeyance if the court so desires. Telling the party, asking the parties to go for it. So in teeth of Millard, paragraph 6, Millard, whether it's a suit for land or not a suit for land. Because this was argued. And I showed a judgment of the Honorable Supreme Court of 2007, which says, Millard, if a suit for specific performance as framed, it's a question, I'll get it finally, agreement to enter into an agreement, whether it will be terminated or not terminated. Millard, if there's a forum selection clause, which was in Indore, and the property was in Gurgaon, and the property was in Delhi. Milord, court, Gurgaon, the forum selection clause in Delhi, court says no, the Supreme Court, that look, it is not a, the forum selection clause cannot be pressed into operation in teeth of the provision of section 16 of the Code of Civil Procedure. It's a Supreme Court judgment. Those judgments which my learned friend cites are not the cases for suit for land. One is for money, one is for contract, one is for some other thing, supply contracts, some is for railways. In respect of a suit for land as framed, if there's a forum selection clause, say Mumbai or Chennai, and the property is in Kolkata, would the court proceed with the suit, or the court will dismiss the suit in teeth of section 16D? In a revisional court, Lordship always can see the case of the parties. Now, kindly, and my learned kindly, I just follow. In addition to the above, inter alia charge of the machineries of the fixed assets of the defendants lying at the suit property has been assigned in favor of the plaintiff by the defendant numbers 2 in terms of the assignment agreement. What is this, Millard? Many things.
According to you, the subject matter of the agreement is with regard to the fixed assets, immovable properties situated within the state of West Bengal.
That definition of the assets is there in the agreement itself. Some cases we try to mold the plaint. That's not there. Financial assets is defined. It's schedule 2 of the agreement. If that is defined and the agreement is part of the plaint, can the court say no? Kindly takes the next sum, as he says, 25% of the consideration paid. There was a COVID intervening. There was a default. So, payments have been made.
So those are on merits.
I am not
those
on
are
merits
on
at all.
merits.
Kindly now, takes just one thing, kindly,
Yes.
The merits, Lordship will see, para 13. I am not on merits at all.
3.
Kindly, straight away come to, the cause of action paragraph.
Yes.
Because I think, Lordship has said absolutely rightly, and I try, now, not to, overstep my jurisdiction. Now, kindly, takes, what was the case? 34 and 35 I placed because of readiness and willingness. This is one of, because agreement to enter into an agreement, that pleading. The plaintiff further prays for a declaration, para 34.
Is there a concluded contract, Mr. Ghosh?
How I am paying the money? How I am paying the money? It's not a case I have not paid the money.
What is an agreement to assign? What is the effect of that?
What is the agreement? It's
contract,
absolutely.
Or it's an agreement to enter into a contract?
It's an agreement. If I pay him the money, he will assign the things to me. Like, what? It's put in such a way, Lordship is thinking it's an agreement to assign. No. He has an assigned, this property, is now, assigned to, the defendant number 1, the property of defendant number 2, by way of an assignment. So, if the assignment, I pay him, the amount of 26 crores, it is the property of defendant number 2 is assigned in my favor. So, assignment is the final document. What will challenge? If I there is an assignment of the document itself, which is like a sale. What do I challenge? What is the question of specific performance? So, what we do, in a specific performance suit, agreement for sale, doesn't give any title. It's a right to enforce the agreement. Ultimately, what I am going to get, assignment rights, whatever he had under the assignment agreement, I'll get that rights. This Lordship is thinking agreement for assign. This is the contract, which I pay him the money, I get, the property and the fixed assets.
Yes.
This is the case, This is the case. Now, kindly take, next, the plaintiff is ready and willing. Now, kindly take the forum selection process.
Paragraph
30. Lordship will kindly make a note of paragraph 34.
34.
Where, the declaration has been challenged. Delivery of that cancellation and termination has been challenged. I get an assignment deed. The assignment deed is a document of title. Like, in copyright matter, assignment of copyright, there is no sale, trademark, assignment, arbitration agreement, assignment. This is the final documentation. If I get a final documentation, where is the question of specific performance?
Yes.
Now, para 34, That's Millard, page number 48. Plaintiff further prays for declaration that the letter dated 2nd March 2020 issued by the defendant number 1 to the plaintiff purported to exercise the option to forfeit the money in terms of the agreement aggregating to 6 point is inoperative, incapable being enforced against the plaintiff. The plaintiff is ready and willing to perform the essential terms of the contract and have been
Readiness and
prevented.
willingness.
Yes, have been prevented. Now, Millard, kindly take Millard the major point. Now, Millard, paragraph 39. Both the agreements, it has a Calcutta stamp, Millard. That's neither here, that's on evidence. This is a pleading.
Yes.
Both the agreements dated 15th January 2020 were entered into at the defendant number 2's registered office as Foreshore Row, Howrah within the jurisdiction. The agreement was prepared on a stamp paper purchased in West Bengal. I'll show you, Millard, for Lordship's Millard satisfaction. The payment of 6.5 crores on 3rd, 4th, and 10th January was also by of electronic transfer from the plaintiff's account maintained.
So according to you, part of cause of action, if not whole, is within Calcutta.
Yes.
Is
Now,
within
Millard,
the jurisdiction of the commercial court.
Now, Millard, kindly take Millard. In Calcutta, the agreement was duly performed by various steps taken from the plaintiffs from within the jurisdiction. All expenses in furtherance of the agreement for reopening of the defendant's jute mill at Foreshore Road, Howrah within the jurisdiction. So it's a step for opening a jute mill. Now, naturally, a jute mill will be an immovable property. Next, the entire cause of action has arisen partly within the jurisdiction, partly within the jurisdiction of this learned.
What is the meaning of this sentence, Mr. Ghosh?
This is Millard partly within and partly outside should be. This is Millard not happily drafted. The purported forum selection clause containing is enforceable inoperative as the immovable property, which the subject matter of the aforesaid agreement is situated within the territorial limits of learned court forming financial assets as set out in Schedule 1. Millard, now we have to go on the next page, Millard. Next volume.
Yes, yes.
That's to go. I'm very sorry for that.
No.
Very, very sorry. Agreement, that's Millard, page 151. Plaintiff states that civil suit number such and such is pending in Howrah.
And with regard to the jurisdiction, paragraph 40 is your specific statement.
The suit is in nature of suit for land, namely a jute mill situated at Howrah. Charge over the jute mill at Howrah, which have been assigned by the defendant number 1 by executing a registered deed of assignment in favor of the plaintiff. This is the catch. Millard, he has a registered deed of assignment. There is an agreement to assign. Because the mother agreement is assignment. The final agreement. So agreement for assignment, what he has got by way of his registered deed of assignment. So Millard, naturally it will come to me. I get a final Millard deed of assignment only. So Millard, the final documentation is a registered deed of assignment. The plaintiff was entitled all right, title, interest in respect of the suit property with the learned so the obligation cast in the proper defendant cannot act contrary to the said agreement, etc., etc. Now, Millard, kindly take Millard, paragraph 43 also. Inasmuch as the immovable property forming the subject matter of the present suit forms the financial assets charged in relation whereof has been assigned in favor of the plaintiff by the defendant number 1 is situated in Howrah jurisdiction, commercial court has jurisdiction to try. Now, Millard, kindly Millard, Lordship has looked at the prayer. I'm not pressing the prayer. There is a schedule of property which Lordship will find Millard at Millard, page 28. It's an immovable property pleaded.
Yes.
Now, Millard, kindly have a look at the agreement to assign, which Millard or Millard, it's Millard, an agreement which the parties perform. Ultimately, I get a documents of assignment which is with him, Millard. Because Millard, there was a pari passu charge of Federal Bank and State Bank of India in respect of the financial assets in question. We have already, Millard, settled with State Bank of India. We want to run the mill. There's a lead consortium banker, Millard. There is a settlement. The consortium lead bank has settled. The another suit which we have filed has been settled between the parties. This is the second suit we offered settlement. Naturally, Millard, if he is not willing, court cannot enforce a settlement. It is not at will. It's not, court doesn't have the power except requesting the parties if one makes under section 89. That application I have also filed. Now, Millard, kindly have a look at the agreement at page 44.
Yes.
Again, Millard, Lordship has to go to the first one.
Yes, 44.
44.
Yes.
Agreement to assign. Millard, the parties are my learned friend's client, JMFARC, intending assigner.
Yes.
So, Millard, he intends to assign. Now, my lord, next page. Obinandon Holding, বলছি ওটা পড়ে Obinandon Holding Private Limited, the plaintiff, intending assignee. Now, Lordship just takes page 45. The stamp paper has been purchased in Kolkata. That is, my lord, pleading in the plaint. So, nothing, my lord, contrary to documents have been pleaded.
Yes.
Now, my lord, kindly takes, my lord, definition portion 1B, financial assets. Financial assets means the facility more particularly described in Schedule 1 herein below, originally availed by the borrower from the bank and now intending assigner, under or pursuant to the agreement, deeds and documents executes all amounts due to the intending assigner by the borrower in respect thereof, including principal, interest, compound interest, all monies whatsoever, stipulated in or payable by the borrower, intending assigner in respect thereof, together with any security interest created to secure the repayment. My learned friend is a asset reconstruction company as defined under section 4 and 5 of the Surface Act. What does security interest mean? So interest in a property. Now, my lord, kindly look, my lord, and the consideration is 26 crores. I, my lord, openly said I get 26 crores plus some interest. Now, my lord, kindly have a look at, my lord, just the schedule. What is the financial assets? Because I kindly look, my lord, schedule 1 at page 52.
Yes.
Primary security, working capital loan.
How much time you will take?
Lord, I will try to wind up, my lord. Tomorrow is a lesser day for your lordship, except Monday, because there will be, my lord, a monthly list on Monday. Otherwise, I am here. 11th only I have difficulty because of my personal difficulty.
Today you have difficulty in the second half.
Second half, some matters are speaking, spongy matters are taken up, my lord, for that bench, and I'm in some difficulty. It's a 2 p.m. fixed by.
Only difficulty is that I will forget. That's the reason.
I am free tomorrow morning. I'll conclude it. Tomorrow, and today is any event 3:30, my lord. Blocking it, my lord, creates, my lord, lot of difficulty and people outside court. Like Mr. Partho Pratim Rai will get after me, my batch. Tomorrow, lordship, can keep it. I'll be there, my lord. I'll keep myself free. Tomorrow, Monday, anything, I'll come and finish up the matter.
Tomorrow you will be having 3:30, no?
I do not know, lordship keeps it. I am here. I leave it to your lordship. I leave it to your lordship. It's always a pleasure, my lord, to argue.
Heard Mr. Banerjee, learned senior advocate for the petitioner. Thank you.
Your Lordship, we were having this matter, item 20, Your Lordship, Abhinandan, where I was being led by Mr. Ratnanko Banerjee. Your Lordship, I think my colleague took tomorrow's date, Your Lordship. In this matter, Mr. Ratnanko Banerjee is also not there, Your Lordship, and tomorrow is Muharram, so I'm the advocate on record, and even I am not there. My other side is also here, and he's also assisting Mr. Banerjee in one matter tomorrow in NCLT. So, if Monday,
করে দিন তাহলে 10 weeks position বলেছি তারপরে নেক্সট উইক
obliged, Your Lordship.
ইয়েস দেখে নেবেন ওটা তো অর্ডার
Item number 21.
21 ইয়েস
I am for the petition. This matter is for expeditious trial of the proceeding. On last occasion, your lordship asked me the name of the learned advocate appearing before the learned court below Mr. Devashish Chakraborty is appearing for the plaintiff.
Since I'm not inclined to take up this matter on first. Before the Honorable Chief Justice for necessary orders. Yes.
22, my lord, I appear on behalf of the petitioner, my lord. Lord, by the impugned order. Lord,
Yes, Mr. Mundal, any difficulty to
no,
take
my lord,
up?
I have accepted. Lord, by the impugned order, my lord, the amendment of plaint has been allowed, my lord. I am the defendant in this suit, my lord. My lord, firstly, may I
Amendment
point out,
of
my lord-
plaint has been allowed.
Yes, my lord.
Yes, what is the difficulty? You file an additional
My lord,
statement.
my lord, kindly, my lord, sees page 45. Lord, suit is proceeding against the dead persons. In that situation, my lord, this application has been fixed for hearing, my lord, on the next date. In the meantime, my lord, amendment has been allowed.
Yes, what is the difficulty?
No, my lord,
The suit is against the dead person, take appropriate steps.
Then, my lord,
Nothing prevents you from
then,
taking that.
my lord, only one thing, my lord. What in by way of amendment, my lord, they are challenging, my lord, two deeds. Now, my lord, that
What is
two
the suit
deeds-
for?
Suit for, my lord, partition, declaration, and permanent injunction. Lord, kindly, my lord, comes to page 32, my lord. Here, my lord, I have stated, my lord, all the details of the deeds, my lord.
This is a suit for partition.
Partition, my lord.
Yes.
My lord. Now, my lord, kindly, my lord, comes to page 32, para 14, my lord. Para 14 onwards. My lord, here, my lord, I have stated all the details of the deeds, my lord, by virtue of which, my lord, I am tracing my title.
Yes.
Now, my lord,
So according to you, you're the exclusive owner.
according to me, I am the exclusive owner.
Yes.
My lord, and now by way of amendment, they are challenging these deeds. I have already stated the particulars of the deed way back in 2009. Now, my lord, they have filed this application, Lord, on 2019, my lord. Amendment application has been filed in 2019, challenging the deeds. Page.
What is the miscase for?
Miscase was, my lord, for 39-2A. 39-2A. Page 33, my lord.
Just give me a minute.
Yes.
What is the application for recall?
Call, my lord.
No. Since I'm not inclined to take up this matter on personal ground,
Lordship, I am for the landlord plaintiff petitioner.
yes.
Lordship, suit of 2002, it was decreed in my favor. I put the decree into execution, and Lordship, the original defendant tenant vacated the premises. And in the execution proceeding, one person claimed subtenant came and filed an application under Order 1, Rule 10(2). And Lordship, he died, his son came, and he also tried to file the substitution application. And Lordship, challenging that, we filed an revisional application, and Honorable Justice Prosenjit Mondal has, his Lordship then was passed an order of expeditious disposal. And Lordship, what the learned court below did, the learned court below dismissed my execution proceeding. And Lordship, challenging that.
Where your execution proceeding had not been dismissed, it has been
Lordship,
stayed.
No, Lordship, that is the last order which I have challenged in this revisional application. Lord, kindly come to the page 22.
Yes.
Page 22, para 7. This was the revisional application and the judgment passed by the Honorable Justice Prosenjit Biswas. Lordship, it is a case of the sitting over the judgment of Honorable High Court. Lordship, got page 22, para 7.
22, para 7.
7. After getting the decree of ejectment in connection with ejectment suit number.
Yes.
After getting the decree of ejectment in connection with ejectment suit number such and such, the decree holder petitioner herein put the decree into execution being so and so. In fact, father of the opposite party number 7, so and so was not a party to the said ejectment suit instituted by the plaintiff. When the decree passed in the ejectment suit was put into execution, then such and such filed an application under Order 1, Rule 10(2) with prayer for adding himself as a necessary party in the said execution case, which was turned down by the learned executing court. Thereafter, such and such cases was filed. Now, Lordship, kindly come to page 23, last lines of the paragraph 7, last few lines. It is nowhere in the said order that a decree holder got possession of the entire suit premises. Moreover, appellate court did not pass any order directing upon the execution court to dispose of the said application in view of the order dated such and such.
No, why are you saying that it's sitting over the judgment of this court?
Lordship, now come to page 26, paragraph 15.
Yes, I've seen that.
Learned
So there was a disposal to, there was a direction to dispose of the execution case.
Lordship, now
that means the miscellaneous case will not be disposed of.
No, Lordship, disposed of.
It's pending, so it has been said that the miscellaneous execution case should be stayed till the disposal. That has to be done. Unless the mis case is decided, how can the execution case proceed with?
But Lordship, then Lordship, I ask to myself, what is the importance of Honorable High Court's order?
That I'm clarifying. This application under Article 227 of the Constitution of India
I am for the pension.
Yes.
That is that matter.
Matter.
Where my building tribunal.
And I have
appeal
received
is pending,
instruction to appear on behalf of the
building
court.
tribunal appeal is pending. I paid for stay of the execution of the order passed by the SOB. And that was rejected with a cost of rupees 10. I mean, with a cost of rupees 10,000. And against that order, I have come up before your lordship. Last occasion, your lordship was pleased to direct me to produce the plan. So I am annexing a plan along with some other documents with a supplementary affidavit. Your lordship kindly accept this.
Yes, Mr. Mukherjee, you are for the corporation.
I have received instruction to appear on the corporation.
If a 4 minutes, we have not served your lordship direction.
But no caveat is there. That is why I did not.
There, not that to serve all the parties.
Where is the direction?
That
There is no direction.
No direction.
No.
No.
By which order I have directed them to serve?
I'm sorry.
No. Because there is no caveat.
You are the complainant.
Yes. My learned friend is the complainant.
Yes, Mr. Mukherjee and Mr. Bhattacharjee, an order of demolition, there is a provision of appeal before the municipal building tribunal. So unless the order is stayed and in the meantime the order of demolition is implemented, what remains to be decided in the appeal?
Let copy start and your lordship take it up Monday. I will submit.
Monday the monthly list, that is the difficult.
ছুটি হবে
All I can do, there are two options. I can direct the miscellaneous appeal to be disposed of, in the meantime stay, or I am staying the order of demolition. I will hear all of you. I am keeping this matter for hearing. These are the two options.
But kindly give me 2 minutes.
Because since you have not lodged a caveat, I can direct them to. So these are the two options. Miscellaneous, the appeal before the tribunal, I can direct to be decided within.
When we came before your lordship, lordship kindly give.
Yes, but it is to be stayed. Demolition order is to be stayed.
But in the meantime,
if it is implemented, then.
But yesterday I have
received. Or if Mr. Mukherjee undertakes that he will not take steps.
Mukherjee is here.
Mr. Mukherjee undertakes, I will record his undertaking and I will.
Only your lordship, if your lordship take up to his name,
All right, but in the meantime, it is to be stayed. Yes, Mr. Mukherjee.
Kindly see internal page 3 of the order.
Internal page
3 of the order of the tribunal.
Yes.
Learned advocate for the KMC submitted that the honorable
learned advocate for the KMC.
Internal page 2, my lord, here my lord 3.
2 or 3?
But it is
2. No, 2. Internal page 2.
Yes, KMC submitted.
Submitted that the honorable court's order dated 15 December 23 in WPNM shows that the appellant submitted before the honorable high court that there is a sanction plan issued by the corporation and the construction was made long back, but in fact the appellant has not obtained any sanction plan. No sanction plan has been produced by the appellant either before the extraordinary civil building or before this tribunal. The inspection report dated 27 to 23 shows that it is a G+3 story building. The corporation issues stop work notice. In spite of such notice, the appellant continued to make the illegal construction for which further stop work notice and FIR was lodged against him. The infringement statement shows that there are the major infringements of the multiple numbers. In fact, the appellant has committed gross violation of KMC Act. There is no privacy case and balance of convenience in favor of this instant application. Learned advocate for the KMC argued to reject the instant application. Now, my lord, if your lordship, if my learned senior friend produce the sanction building plan before your lordship, may I just see with your lordship leave to see the sanction plan? Because this is contrary to the submission recorded by the tribunal.
Mr. Mukherjee, I follow your submission. Then nothing remains to be decided in the appeal. You say so. I will treat the appeal as closed. I will consider this. Because if you say that yes, he has violated, so the appeal should be dismissed.
I am bound by your lordship's order. Your lordship directed last occasion what I have seen from your lordship.
We have produced something. It will be considered.
Kindly consider once the sanction building, like if it is sanctioned, but I have nothing to say. I am obeyed by your lordship's order. I am bound to obey. Sir, I was sanction building plan.
Your lordship kindly direct me to stay the.
May I just see the sanction building plan?
Produce.
Give him a copy.
Very good. But at the present,
give him a copy of the supplementary affidavit. He wants to see the sanction building plan.
This was submitted.
But this is not sanction. This was submitted only. Where is the sanction by the corporation?
No, next page. Please see, there is a stamp.
Yes. But may I just see once, because this copy, then maybe a receipt copy.
Original.
But if it is
Yes, where is the sanction, Mr. Chatterjee?
That was submitted before the.
So there is no plan. Do you have any sanction plan? Do you have any sanction plan?
But the plan which I obtained from my client, that I have been annexed in my
Is
submitted.
this the sanction plan?
That I cannot say. But
You
it is
cannot say you have not.
It is submitted. It was submitted.
No sanction has been granted.
Kindly consider one thing. Building was constructed in 1995.
1995, you do not get the immunity of the previous Corporation Act. In the previous Corporation Act, 12 years immunity was there. That's not there in the 1980s.
But only building premises number is one. But there are 3 heart. If any construction has been made, that was not made by my client.
Maybe.
But notice has been pasted in my.
That does not make it a regular authorized one. If it is unauthorized, it's
Let it be
unauthorized.
decided in my appeal, my lord. Let it be decided. Let it be decided till such time, your lordship, kindly stay the.
What is the stage of the appeal?
Stage of the year. The blood last on the yesterday,
17th
I have
of
received this
September,
notice.
I am directing the appeal to be.
But on 20.
Appeal has been fixed on July, in the month of July, no?
September.
September.
Our final hearing. For 2024, Justice Kaushik Chandramlal, in his application, but
ওটা ট্রাইব্যুনালে অলরেডি ফাইল করে
tribunal
there is the order. The tribunal shall decide the extension of stay in accordance with law without.
Will decide the.
Shall decide the extension of stay in accordance with law without being influenced by the order passed by in this writ petition. Needless to mention that in the event the stay order is not extended by the tribunal, the corporation will be at liberty to proceed demolition. This is the order passed by this honorable court in a writ application. But against that, he have not prepared.
Mr. Bhattacharya, he has availed of a statutory remedy. There is an order of demolition passed. Statute says that he has to approach before the tribunal. He has approached before the tribunal. Yes, stay is not a matter of right. So stay has been rejected. What remains to be decided in the appeal? And stay has been rejected. Mr. Mukherjee's client will go tomorrow and demolish. So what he will do with the appeal? Mr. Bhattacharya, what he will do with the appeal? If ultimately the tribunal says no, there was a plan, it cannot be said to be unauthorized, what will happen? You will compensate that?
But that's why your lordship on the first day asked my landed senior friend to produce the building plan. That's it fallen from your lordship. We are bound to.
I am directing the tribunal to consider this and to pass an order. Decide the appeal. Till that time, don't take any step.
Then if they don't have the sanction plan, that is a
that will be decided.
That is
If I have no sanction plan, my appeal will be dismissed.
But kindly, but that's why your lordship on the first day directed him to produce the sanction plan. Then if I say that what he has produced, that is he is just misrepresent before your lordship.
Where is the earlier order passed by the writ court?
Yes, kindly see. Kindly see page 29.
29.
What happened, my lord? Na, ওইটা ছিল না. But what happened, my lord? That this honorable court did not entertain on the ground, on the score, that my lord, he has already approached before the tribunal.
Subsequently, I filed the stay application, my lord. That has been rejected with a cost, my lord.
Demolition order 27 June 24. Not a single building plan, and the submission was he is not my lord person responsible. Then why he is coming?
Because my the notice has been pasted in my heart. That is why I have come up before your lordship, my lord.
But the only thing is that what remains to be decided in the appeal.
I understand, but if a person, what we have learned from your lordship, my lord, that if he don't have a sanction, there's a prima facie case. In injunction, there must be a prima facie case. If a person, my lord, it is not that as if he filed an
not injunction, stay.
Stay. It is not that stay is my indirectly restraining the corporation not to demolish or not to implement the order. Now suppose today, then where he has to.
Mr. Mukherjee, that is
I
not
understand.
there.
But
So what will be decided in the appeal then? If today you go and demolish.
if this observation, that what it is observation of the tribunal that there is no sanction plan, he could not produce.
No, show me that finding. It's your submission which has been recorded. No finding of the tribunal. Show me that.
Page 3, last line, last paragraph.
Yes.
At the outset, the appellant has failed to produce any sanction plan.
Yes.
The CR shows, this is the finding of the tribunal.
Yes.
The CR shows that the appellant did not raise the issue before the executive engineer civil that Maloti Devi is the actual person responsible, not himself. The reply to the RTI shows that there is no sanction plan. Everything has been considered. The infringement statement, kindly see the area. If today something happened, then the corporation will kindly clarify that. Corporation will not be liable. If something happened, if the building is demolished or something happened due to rainy season, then corporation will not be liable.
Yes, Mr. Chatterjee, give an undertaking to that effect. If something happens, corporation will not be responsible. You will take the entire responsibility.
Already made an application for stability, structure stability report.
Mr. Chatterjee, that is neither here. That is neither here nor there. Till date, you have not produced any sanction plan. First. Second,
And
but
second,
Mr. Mukherjee, you file an undertaking that if anything happens, you will take care of that. Corporation will not be responsible.
File an affidavit. Can you allow the but to hear the appeal, my lord?
Yes, yes.
I
will direct that. If in the meantime something happens, you file an undertaking that.
Mr. Chatterjee, we should not file this supplementary affidavit because this is not the sanction building plan.
But that will be decided by your lordship, my lord, whether supplementary will be accepted or not. That will be decided by your lordship.
Yes, please file an affidavit that he will take all the responsibility if something happens during the pendency of the appeal.
Yes, yes. I shall file to that effect.
Ashwini.
But till such time, your lordship kindly give some relief. Till such time.
How much time you want to file an affidavit?
Within one week. Within 1 week.
Within 1 week.
One thing, madam. Yesterday, I have received this notice that to vacate the premises within 4 nights. Yesterday.
Mr. Chatterjee, rightly done. If there is no sanction plan,
No, anyway, that will be decided in the appeal. Your lordship kindly give some time.
can be decided here itself.
No, I shall file undertaking as per your lordship direction.
Corporation Act din to.
I shall file undertaking.
What will be decided in the appeal? What remains to be decided? What will
My
be?
appeal is pending, your lordship.
Yes, yes. I am disposing of the appeal here and now from here. Show me
Your lordship
any wrong.
My
Mr. Chatterjee, show me.
lordship directed me to file an undertaking. My client will definitely.
That is one way. Show me what remains in the appeal. After this finding, if you prima facie cannot show anything, that you have a sanction plan. And what's wrong in the order?
Any construction.
Mr. Chatterjee, stay is not a matter of course.
Your lordship kindly.
Stay is not a matter of
has been
course.
made in my house.
Stay is not a matter of course.
If any construction has been made, that was by Maloti Devi.
Yes, yes.
But notice has been pasted
That is the
in my
rules
house.
dilen Corporation Act din, Kolkata Corporation Act.
Stop work notice, FIR lodge. Stop work notice, FIR lodge. Still construction
Mr.
continuing.
Chatterjee, I have held that.
Your lordship kindly appoint any special officer whether my heart any construction has been made or not.
No. That is neither here nor there. It is West Bengal দিচ্ছেন Kolkata Corporation Act. There is nothing remains to be decided in the appeal, Mr. Chatterjee.
Some breathing time, your lordship.
What relief?
But I shall file an undertaking. I shall file an undertaking as per your lordship direction.
5-storied building without any sanction. That's the finding. 5-storied building.
Your lordship.
And in the supplementary affidavit, what you have produced? Let me see.
But it's a 4-story. 4-story building. That was made in 1995.
Annexure দেওয়া আছে হাইকোর্টে অর্ডারে ওটা মিস্টেক করে ওটা 5 স্টোরি করেছিল
Subsequently, that was rectified by the corporation. That it is a 4-story.
What have you
building.
stated in the supplementary affidavit?
Well, I have stated in supplementary affidavit, my lord, that the plan which was submitted by my client as well as the inspection book.
Mr. Chatterjee, what is this plan for? What is the purpose of this plan? Please tell me from the plan.
It was.
What is the plan for? For what purpose? This is not also the plan for sanction. This is not a plan for sanction.
It's admitted there is no stamp for sanction.
No, no, no.
It was
Please,
submitted.
I'm not also on that. What is the plan for?
এই দেখুন এটা কি এইটা এটা এটা কিসের দেখুন
এই অরিজিনালটা
এখানটা দেখুন এখানটা
অরিজিনাল a plan showing the existing structure at premises number so and so.
When that is submitted, Mr. Chatterjee?
You know,
when this plan is submitted?
It was submitted
For what purpose?
For 2008-9.
No, no, no. I'm not asking the time. For what purpose this type of plan is submitted? Do you know that?
For this construction of the building.
Existing structure is there. This is the plan for existing structure. This is not a plan for proposed construction for sanction. This is the plan for existing structure. Do you know when this is submitted? I'm not asking you the time.
This is the original, my lord. It was.
Yes.
Existing structure.
When that is submitted? Not the date, not the date. When such a plan, for what purpose such a plan is submitted?
As per your lordship's content, it is after construction.
Admit plan বলে এটাকে
So existing means what is existing? This is not the sanction plan. Order is this application No order.
Yes. Number 25.
And for the opposite party.
Yes.
Your Lordship, I am the petitioner in person. Under order, impugned order of 19 May 2025, which has been passed by the Junior Division Civil Judge.
Yes.
Adjournment petition which has been filed along with the High Court 19 May Court number 652, which has also been filed. So there are three cases which are, as in person, I was before the Honorable High Court. So I have applied for that. And these serious prejudice to the principle of law under Order 22 Rule 9, because there is a APESCO judgment that is Madan Naik, 1983.
No, this order, please kindly come to the impugned order.
Your Lordship.
Because I cannot go beyond the impugned order.
Your Lordship.
Please satisfy me. What is the infirmity in the impugned order? Please place the impugned order.
Today is a fixed for further hearing. Petition under section 151.
What is the 151 application for?
That 151 application which has been filed by the defendant.
Yes, for what?
For the cancellation of his plain case, Lordship, the reason is there were three deeds that are involved in this.
No, have you annexed the 151 application here?
Lordship, we had filed one revisional application before this court for expeditious disposal of the 151
Yes, yes.
applications.
Please.
Have a copy of that with me if Lordship wants. I can provide.
So by this order, only 20th of June was fixed for hearing of the 151 application.
Your Lordship.
So I'm directing the 151 to be disposed of.
Yes, Lordship, within any specified.
But there is a question by Lordship I want to place, because there are 4 CO applications which are pending on the main issue. Main issue is that is a functus of
that I cannot decide it here. By this, only a date has been fixed. I am directing 151 to be disposed of. When the other civil division application comes, I will consider that.
Your Lordship, I am accepting your verdict. But one thing I like to highlight, because that order which has been passed by the predecessor 7th ADJ, which has been overturned. That's why this is your application. And that is a function of...
Here only by this, you are challenging the order dated 19th of May. 19th of May, only a date has been fixed. Nothing has been done. When the other matter comes, I will consider that.
No, but they are going to, Lordship, the trial court is going to dispose of the trial suit, title suit.
For that, you take appropriate steps there.
Okay.
So, Ashun, this application under Article 226. Yes.
Item number 26, Your Lordship is appearing for the first time. By an order dated 18 June of 2025, Your Lordship was pleased to grant me the liberty to file a supplementary affidavit for
Yes.
bringing in the records. Kindly take on record. Your Lordship, the civil revision is arising out of an order passed by the learned Commercial Court Rajarhat dismissing my application under Order 7, Rule 11. Now, Your Lordship, may I draw Your Lordship's attention to the impugned order
What is the
itself?
impugned order?
Yes, impugned order is, Your Lordship, at page number 171.
Impugned order is a certified copy,
It is a certified copy.
cannot be paginated.
It's not paginated, Your Lordship. It's after page number 170. It is
Yes.
there. Yes.
18th of March 2025.
18th of March 2025, Your
Yes.
Lordship.
Order 7 Rule 11.
Order 7, Rule 11.
Rejected.
Yes, Your Lordship.
What are the
rejected.
grounds of Order 7 Rule 11?
Order 7, Rule 11, Your Lordship, I took two grounds. A few other grounds are there, but two specific grounds were that first, the dispute that is involved between the parties had a property which is exclusively used in trade and commerce, but that is not the only unit for justification of a commercial dispute, because the law is settled. Transaction between the parties would have commercial interest. Second, at the time of taking leave of court under Section 12A of the Commercial Courts Act, which is for the which is for dispensation of leave for mediation, which is a pre-suit requirement, Your Lordship, suppression was made and necessary pleadings were not put for taking such leave. These are my two main grounds.
Did you apply for revocation of that leave?
By way of filing Order 7, Rule 11, Your Lordship. Not only
Order
that.
7 Rule 11 is a different thing. That is on the plaintiff itself. So
Yes.
here leave was sought for.
Leave was sought for.
Leave was also granted.
Leave was also granted.
So it cannot be a ground under Order 7 Rule 11.
Your Lordship.
You may have a right to pray for revocation of the leave.
Yes, and
that cannot be a ground under Order 7 Rule.
Your Lordship, the settled law is court can suo moto reject a plaint under Order 12A.
That is all right, but here is a case where a leave has been granted.
Yes, Your
If
Lordship.
leave has not been granted, you are absolutely correct. Without an application, court can.
Yes.
But it's not a case where leave was not granted. It's a case where leave has been granted. You say leave was obtained by suppressing certain facts.
Yes.
So suppression of certain facts, so it has to be decided. Cannot be under Order 7 Rule 11 because it cannot be seen from the reading of a plaint itself. Order 7 Rule 11, you have to restrict yourself
within
to
the plaint.
statements made in the plaint.
Yes, Your Lordship. And the
So,
and
by way of suppression, 12A leave was granted. That cannot be a ground for Order
Your
7
Lordship, the suppression would be evident from the pleadings of the plaint and the documents annexed thereto. So it is not only the pleadings are contrary to the documents that were referred to at the time of taking the leave of this honorable of the learned.
a ground for revocation of the leave.
Yes, Your Lordship, and the revocation of such leave, if it is if I can.
Have you paid for revocation of the leave?
Your Lordship, the grounds are there in my application under Order 7 Rule 11.
7 Rule 11, madam, is in a different context altogether.
But Your Lordship, the court can so much to decide. Record
Yes, but when the Order 7 Rule 11 can be allowed or the plaint can be rejected if leave is not sought for. Here is not a case that leave was not sought for, leave was not granted. In this case, leave was granted. So how can it be under Order 7 Rule 11? 12A bar cannot apply here. For what proposition, madam, you are citing decision?
Yes, Your Lordship, the fact that.
What is the proposition? For what proposition?
Your Lordship, the proposition is under Section 12A, which says that any suit which is instituted under 2015 Act without complying with 12A is liable to be rejected under Order 7 Rule 11.
That you did not so decision before the High Court.
But Your Lordship, it says that to be rejected.
Here is a case where the leave has been granted, madam.
Yes, Your Lordship.
That's the distinction. Here is a case where leave has been granted.
Yes.
So how can it be barred under 12A? You are on a different footing altogether. You say leave would not have been granted. That is a different cause of action.
Yes.
So 12A leave was sought for, granted also. Court has granted.
Yes.
So how can you say that leave was not granted?
It is coming under the provision of B, barred by law.
Yes. Barred by law, yes. If leave was not granted, here leave was granted. How can it be barred by law?
Because Your Lordship,
we come to Section 12A of the Commercial Courts Act. Place 12A. What does it contemplate?
Yes, your lordship, a suit which does not contemplate any urgent interim relief under this act shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by the rules and regulations. And then it speaks of the rules and everything.
So now here is the case where according to the plaintiff, they have sought for urgent relief. They have paid for leave under 12A. Leave was granted. So where is the question of bar under 12A?
May I, your lordship, be permitted to place this judgment once?
Which judgment?
This is your lordship 2025 SCC on SC 1129.
What is the cost at?
Dhanbad Fuels Private Limited versus Union of India. Where?
It takes into consideration the Patil of
Patil Automation, Yamini Manohar.
This is the recent decision.
Yes, your lordship.
Yes. Kindly come to paragraph
62.
Yes. Where the quotations are there, sub-paragraphs are there, conclusion at page 62. It's not a dispute, 12A is mandatory, leave has to be sought. That has been complied with here.
Yes.
What are the other grounds in order?
Yes, other ground, your lordship, is that it has been laid by the judgments passed by this honorable court and the Supreme Court, your lordship. Lady Moon is the one judgment, another is your lordship, the Ambala and
What
Sarab.
proposition?
Proposition is your lordship, the parties which will file a suit before a commercial court would have to satisfy that the transaction involved commercial interest. Now, there is categories, your lordship, since the list is exhaustive on the point that what are the commercial disputes. What happened is, your lordship, the property which was in dispute.
Which clause you are invoking?
Yes, it is 21C7, read with explanation. May I read, your lordship? It says that commercial 1C7, Roman 7. Agreements relating to immovable property used exclusively in trade or commerce. Now, your lordship, read with explanation is also there. It will be added to that because a commercial dispute shall not cease to be a commercial dispute merely because it involves action for recovery of immovable property or for realization of
the dispute here.
Yes, your lordship, the dispute is this is a suit for specific performance of a particular agreement has been sought for. Now, what happened, your lordship? The plaintiff is a sister of the defendant number one.
So why do you say that it does not fall within the?
Because, your lordship, the commercial
relating to an immovable property.
Yes, but what the court says and the Supreme Court judgment says, the transaction would involve a commercial interest. Commercial interest has to be there.
Property is being used.
Property is used for, your lordship, trade or commerce. No, but your lordship, kindly appreciate the fact the plaintiff has category.
Well settled.
Your lordship, yes.
Sir, well settled.
Yes, your lordship. The thing is, in HON'BLE and Sarabhai 2021 SCC 585, it has been categorically mentioned that commercial fair disposal of commercial litigation so as to benefit whom? Litigants, especially those who are engaged in trade and commerce. Lady Moon, your lordship, of our honorable court, where the transaction was
the agreement.
Yes. Now, in the
Show me the plain.
Yes, your lordship. The plaintiff, your lordship, at page number 27, starts from 27.
Yes.
Now, kindly see the submissions of the plaintiff herself. Now, your lordship, the plaintiff herself states, if your lordship sees paragraph number 1, it says that the pleadings
Please
are.
give me 5 minutes.
Yes. sees paragraph number 1. Kindly come to your lordship, paragraph now.
Yes.
The plaintiff herself has addressed and approached this honorable court on the foundation that she is a household lady having family values and the dispute in relation to shares in the properties between family members. Now, let me show you lordship from the plaint. These are the women. Now, kindly come to paragraph number 1. First line. The plaintiff and the defendants are full blood sister and brother respectively.
Those are the introduction of the parties.
Not only
What
that.
is the subject matter of the dispute that is to be taken into consideration?
Indeed. What happened, your lordship? Lady Moon Towers Private Limited versus Mahindra Investment Advisors. From the names of the parties, it is seen that these are companies. What happened in this case, your lordship? A loan was granted by one company to another company. And in terms of the commercial code said, it has to be a commercial dispute. But this honorable court stated that no, this was a friendly loan. Parties were known to each other. There was no commercial interest. So just because, your lordship, a property is in use, just because a transaction is happening, just because an element of profit is also involved, that cannot be the determination of a commercial dispute, your lordship. Commercial interest, may I kindly, your lordship?
Yes.
I'll just place this judgment. Paragraph number 20.
Yes.
This case was much more complicated, your lordship. Kindly say, I'll just read the paragraph. The definition section.
According to you, this is a less complicated one. The case on hand.
It is, your lordship, to be very honest, because the person who has
Yes.
filed a plaint, yes, the definition section of 2015 Act only contemplates a commercial dispute, not any other form of dispute. Now, the gradation is given. Yes, the gradation of the disputes taking into account all possible forms of agreements from which a commercial dispute may arise makes it clear that the framers of the statute get emphasized on the commercial flavor of the transaction as opposed to agreements entered into between the parties without a commercial purpose. The qualification of the person being merchant, banker, trader, financial experts in financiers imparts an unimpeachable commercial flavor in the transaction and the resulting dispute. Here, your lordship, financiers were involved, but still, this was not considered commercial dispute. Why? Your lordship, the commercial purpose would generally mean, this is the meaning, a transaction by which a person's commercial or economic interests may be advanced and transaction and would result in an economic benefit to that person. It would not include an agreement where profit making is an incidental outcome of the transaction or may happen by accident. Although a hand loan, for example, because this was the dispute herein, is given by a person or entity to another with the expected outcome of the principal sum being returned with interest, the essential commercial flavor in such loan may be lost by the reason of the informal terms under which the money is lent in advance and consequent uncertainty which may result therefrom. The requirement of fixing transaction between section 21CI, namely the classes of the persons, can be construed being in aid of what the Act intends to cut down, namely unnecessary wastage of time on ascertaining whether a dispute is commercial dispute. The exhaustive categories of the agreements in 21CI 222 leaves no doubt 2015 Act seeks to bring within its fold an exclusive range of disputes where the underlying purpose of the transaction is a commercial interest of the parties. This is, your lordship, Honorable Calcutta High Court. Now, your lordship, I'll bring your attention to the Supreme Court judgment which deals with the property, which it is, your lordship, one of the iconic judgments that deals with this particular contention that a property, if at all, it has to be exclusively used in trade or commerce or not, and if that becomes a commercial dispute. This is, your lordship, HON'BLE Cerebral Enterprises versus KS Interface.
Are you not carrying the SCC online copy? Because in Monupatro, sometimes some word, some sentence.
I've matched it with the
All right.
SCC.
What is the SCC reference?
Yes, SCC reference is, your lordship. 2020-15 SCC 585. It's in the, your lordship, the
2020
15 SCC
2020 15 SCC
585. If your lordship sees at the top of the judgment, equivalent and neutral citation, second line, second last.
Oh, yes.
Yes, 2020 15 SSCs 585.
Yes. Yes, which paragraphs you are relying upon?
Yes, Your Lordship. Uh, आधा चीज मिल नहीं रहा. Yes, Your Lordship, kindly come to paragraph number 37. Now, what happened? Your Lordship, the plaintiff also relied on this judgment and at the time of submission stopped at paragraph number 37. 37 says a dispute relating to immovable property per se may not be commercial dispute, but it becomes a commercial dispute if it falls under subclause 7 of section 2(1)(c) of the Act. The agreements relating to immovable property used exclusively in trade or commerce. The words used exclusively in trade or commerce are to be interpreted purposefully. The word used denotes actually used, and it cannot be either ready for use or likely to be used or to be used. It should be actually used. Such a wide interpretation could defeat the objects of the Act and fast-tracking procedure discussed above. Now, Your Lordship, the main portion was absolutely omitted by the plaintiff at the time of placing the judgment. In my written notes of submission, I've categorically made it clear that the main portion of the judgment is paragraph number 42, where Honorable Supreme Court couldn't have been more clear about the ingredients that to be taken into consideration. What it says, Your Lordship, the object and purpose of the establishment, the commercial courts, commercial divisions, and the commercial appellate divisions of the High Court is to ensure that the cases involved in commercial disputes are disposed of expeditiously, fairly, and reasonable cost to the litigants. Keeping in view of the object and purpose of the establishment of the Commercial Courts Act and the fast-tracking procedure provided under the Act, statutory provisions, the words incorporated therein are to be meaningfully interpreted. For Your Lordship, for quick disposal of last 3 lines, quick disposal of commercial litigations so as to benefit the litigants, especially those who are engaged in trade and commerce, which in turn will further economic growth of the country. The purpose, Your Lordship, for establishing commercial...
What is the ratio of this decision?
Your Lordship, it has been settled. It has never...
What is the ratio I'm asking you? What's the ratio of this decision?
This has not been reversed anywhere.
Ratio. What is binding is the ratio.
Yes.
What is the ratio of this decision?
It is...
You are referring to one paragraph.
Yes.
They have referred to another paragraph. I'm asking you what's the ratio. It's only the ratio which binds, not every observations made in the judgment.
Yes, but
so
this...
that is why I'm asking you what's the ratio in the judgment.
This is the ratio which binds, Your Lordship, because this...
No, what is the ratio? Please tell me what is the ratio. What has been decided here?
Here, Your Lordship, the decision has been made that the properties that would concern commercial dispute would be used exclusively for trade and commerce, and the usage would be in present continuous or present. It can't be past. And when this decision was made, Your Lordship, there is a reason why it has been categorically made that why people of trade and commerce are to be considered. Today,
what it has been held that is not a commercial dispute in this decision. In this decision,
no, Your Lordship.
Show me that whether the Supreme Court has held that dispute to be a commercial dispute or not.
No, here it has been held. It is commercial dispute only because this.
Yes, Mr. Kormukar. Why are you disturbing? Yes.
Yes.
Paragraph 39 is the fine.
Paragraph 39.
That's the ratio of this judgment.
Yes. Yes, here it was merely it was likely to be used doesn't mean that it would attract the jurisdiction. But Your Lordship, my point is just kindly appreciate a situation. Let's say this is a commercial dispute. let's allow this plaint to be continued to be adjudicated by the Commercial Courts Act. What will happen is, Your Lordship, anybody will come and say that there is a property which is in dispute used in trade and commerce. I am a third party. I am a third party. I'm not even a company. But since the property is used in commercial dispute, I'm not even involved in the business. This should be heard in the commercial courts. If that is so, the purpose of the discrimination between regular court and commercial courts would become futile. This matter could have easily gone to any regular courts and be decided, because the plaintiff herself is saying that she doesn't have any commercial interest. She is a household lady. In the impugned order, Your Lordship, it has been wrongly recorded. It has been, in fact, wrongly recorded that, and the plaintiff, in his written objection, said that she has business or commercial interest. How? Just because the property is used in commercial dispute. She was not even a part of the business ever. That is my contention. And secondly, on a second thing, Your Lordship, the agreement on the basis of which the plaintiff has filed this particular suit, asking for specific relief. The existence of the agreement itself is in dispute. But this is again going into the merit. And there is no point in getting into that. It can be dealt in trial. But when it comes to the fundamental and foundation of the law, when it comes to commercial dispute, it cannot be that if the property is only used in commercial dispute, anybody who is declaring to be a housewife without having a zero involvement in the commercial world can exercise the jurisdiction of the Commercial Courts Act. And I would also request Your Lordship for the last time to consider the 12A. Why? Because, yes.
So these are with regard to those commercial disputes.
Yes.
And 12A.
12A.
Which is the decision we want to cite?
Yes, Your Lordship. Now, when this order was passed by the Learned Commercial Court, Your Lordship, that time this 2025 judgment didn't come. So we refer to Yamini Manohar, Your Lordship, 2024 5 SAC 815. Now, Yamini Manohar is, Your Lordship, very simple. It only focuses on the fact that it says that 12A is mandatory. And if Your Lordship comes to paragraph number 12.
There is no dispute.
There is no dispute.
12A is mandatory, madam. There is no dispute.
Yes.
So it's well settled.
Your Lordship, in this court, there's, Your Lordship, this Honorable Commercial Division of this court, Your Lordship, revoked the 12A leave on the basis of an application under Order 7 Rule 11.
Is there any provision for revocation of a leave under 12A which has been granted? Satisfy me.
Your Lordship, there is an order passed by our High Court where the matter involved infringement of trademark and copyright. It was a passing of suit, Your Lordship, and 12A leave was granted. Your Lordship, we filed an application under Order 7 Rule 11 for revocation because we took the ground for revocation of dispensation, Your Lordship, and this was considered and the 12A leave was revoked.
Which paragraph plaint stood rejected?
Yes. Your Lordship, kindly come to paragraph 15.
15.
15. In view of the above, GA6 stands allowed, which is Your Lordship Order 7 Rule 11 application. There shall be an order in terms of prayer A and B of the master summons. IP Com 28 of 2024, which is the number of the suit, stands dismissed.
That is the suit.
Yes, Your
IP.
Lordship. IP Com. Now, may I be allowed to show Your Lordship the infirmity? It's glaring, Your Lordship. Kindly, Your Lordship, come to the pleading. The pleading, Your Lordship. Kindly come to page number 45, paragraph number 42.
Yes.
Plaint. Your Lordship of the plaint.
Yes.
Page 45, paragraph 42. So, Your Lordship, the plaintiff makes out a case that how plaintiff came to know about the this particular deed of conveyance that was filed that was executed behind her back. On searching through her learned advocate, plaintiff came to know for the first time on 4th September 2022 that the defendant number 1 had sold, transferred, assigned by way of an illegally executed registered deed of conveyance dated 24 January 2022. Now the details have been given. So, Your Lordship, the moment a plaintiff says that it is in her knowledge for the first time, the documents would speak that it is in the knowledge for the first time. I would take Your Lordship to the paragraph of the cause of action. Kindly come to Your Lordship, page 58, paragraph 71. Cause of action, Your Lordship, first arose in 7 September 2021. If Your Lordship comes down to
paragraph
71, page 58.
September, yes.
Yes. Your Lordship, cause of action of the instant suit arose on 7th September because
And suit filed on?
Yes, Your Lordship, suit filed on 10th November 2022. Your Lordship would find it at page number 73 as per the affirming date. I can produce the case details also before Your Lordship. Page 73, kindly see the affirming date, Your Lordship. Place Howrah, date is 10/11/2022. Now, if Your Lordship sees, it says 4th. May I continue, Your Lordship?
All right, there is a caveat, no?
There is a caveat. There is a caveat, Your Lordship.
Have you served?
We haven't served Your Lordship. No, there is no caveat. There is no caveat, Your Lordship.
No caveat.
Your Lordship, there is no caveat. So, yes. Your Lordship kindly remembers the date once. 4th September 2022. Suit filed on 10th November 2022. Your Lordship, definitely urgent relief. But kindly, Your Lordship, one page. Kindly come to Your Lordship, page number 50.
Please serve up on the other side. Petitioner is...
Allow me to finish this up. Misrepresentations. Kindly come to Your
Let
Lordship.
them come because I cannot finally decide.
At least kindly grant us, Your Lordship, stay for the proceeding of the plaint in the lower court.
By the
Number 64.
May I please, Your Lord?
Yes.
In this matter, my lord, I am appearing for the petitioner.
Yes, what is the miscase for?
I am coming, my lord. Before my enter making submission, my lord, I
What
have
is the
prepared
order
supplementary
impugned?
affidavit, my lord, kindly
What is that?
supplementary affidavit, my lord.
Yes, what is the impugned order?
Impugned order, my lord. Landed trial judge, my lord,
Supplementary affidavit.
has set aside an order passed in section 24 of the Hindu Marriage Act in an application, while application was taken up for that is section 25. That means, my lord, at the time of taking up of section 25 application, the order passed in section 24 has been set aside. My lord, predecessor's order has been set aside by the successor judge. That is my main case.
Miscase has been restored, it will be hard.
My lord, kindly have a look, my lord. My lord, there are two cases. Miscase number 23 of 2022.
Yes.
That is, my lord, that is application under section 25.
Yes.
And my lord, just now I have handed over your lordship the supplementary affidavit. Your lordship will find from page number 4, that is miscase 23. The application under section 25. My lord has got it. Page number 23. My lord, that 23. Is, yes, my lord, 23.
Yes.
That is an application under section 25 of Hindu Marriage Act 1995.
Yes.
But my lord, at the time of hearing of this 25 application, my lord, order passed in 24 has been set aside. Twenty-four applications is 92. In this case now 92, 2018. That is, my lord, at page 15 of my supplementary affidavit.
Yes.
My lord, in my supplementary page 15, that is the order passed in section 24. Miss case number 92 of 2018. Ordering page is page 17.
Yes.
It is under the 21 lakhs is last disposed of.
How are you agree? Miscase has been restored. The finding is that some documents were not filed.
No, my lord, no, my lord. Perhaps I cannot, my lord, appreciate. My lord, can you see? This is an.
Sir, what has been done by the impugned order? Please tell me.
Order has been set.
Earlier,
getting the maintenance.
Sir, earlier an order of alimony was passed. Subsequently, a miscase has been filed for setting aside that. That has been allowed by the impugned order, and the miscase has.
No, my lord, no.
So, you please kindly come to the ordering portion.
Ordering portion, my lord.
Yes.
Yes, my lord.
You are challenging the order dated 22nd of April 2024.
No, my lord, order is, original order is 92. My lord, kindly have a look.
Please kindly come to the impugned order which you are challenging.
Impugned order, my lord.
Yes.
The impugned order, my lord, the petition filed by OP husband.
Please kindly come to the ordering part. Kindly come to the ordering part. Yes.
13th April 2022,
yes.
Setting aside the order 22nd 12 2021. That is different case, my lord. Miss case 92 2018. 92 is a case of 24. But this is an application, this miss case 23 is an application of 25. My lord, 25 is neither the appellate court, not the revision court. It is not a case that order 47 has been filed. While deciding the case of 25, My lord, 24 order has been set aside, my lord. Now I am not getting anything, and I am passing my days in starvation with my daughters. I am not
Petitioner is directed to
without
serve-
application, my lord.
Petitioner is What?
Matter, Lordship. The other things matters.
Yes, if you want to do, I am here.
382 number expedition disposal number matrimonial suit, cross-examination of DW2. But since not who
Which is the item? Then have to this
mine is a very small matter. 382.
382.
Yes, cross-examination last
Call it. Call করুন next.
till date, Lord.
Item number 382.
Lord, I am for the petitioner. Lord, kindly see, last cross-examination, every time they are taking time, that is, Lord, your Lordship will get 26th November 2024, and Lord, next date for same purpose is fixed on 5th July.
5th of July.
Yes. Lord, by fraud, practicing fraud, marriage was registered.
So, DW2.
DW2. That is, Lord, the
Last date was 13th of February.
last date, Lord, 26th November 2020.
So thereafter 13th of February.
13th of February. Now, Lord, it is continuing. Next date is fixed for same purpose on 5th July 2024.
5th July 2025.
2025.
Who are you?
I'm for the petitioner, Lord, with a wife.
Wife.
Wife, no, so-called wife.
Alimony is being paid.
No, alimony, nullity.
Oh, nullity.
Yes.
This application under Article 227 of the Constitution of India. Passover. Next.
899.
Yes.
Small issue is concerned, my lord. The erstwhile secretary of a residential association, he filed a suit against the present secretary who had been selected by the entire residents. Subsequent to which, when
what is the order under challenge to that?
My lord, we had filed an application for variation which was not heard.
Order that line rule 4.
My lord.
When have you filed that?
That was filed, my lord, on
No,
19th of August.
You have filed the application for vacating in the miscellaneous appeal. When did
That
you?
has not been heard. 19th of August 2024.
In the miscellaneous appeal?
The miscellaneous appeal. Because
which
in the
order
suit,
records that?
In the suit, my lord.
Which order records that?
Well, comes to page. Application to.
Mr. Jha, I can direct the miscellaneous appeal to be disposed of. Ad interim is being extended from time to time.
And the infirmity that we are facing is the plaintiff, he's bringing bouncers, the residents, they are not allowing him to function.
The miscellaneous appeal to be disposed of. after some you are not ready, sir.
5th January, yes, my lord. I'm praying for not today, only not today, man.
Not today. The learned, this Oishik Chatterjee, Kushal Chatterjee, he usually appears. Passover. Next.
Item number 1208.
Lord, for my lord is forcing me to, my lord, go beyond, my lord, mine.
No, no, no.
Yes.
I'm not forcing you.
Otherwise, your lord, the consequences are, my lord, that it will never be heard.
No, no, no. That is your choice. After 3:30, I started by saying, if you are, I was about to rise.
But your lordship has
Some of you
listened.
said, yes, yes, this is expeditious, that is that. So you are ready. If you are ready, I have to take up.
No, if there is a consequence of this going back to where it was, then there is a problem. My lord, I have a very innocuous spread. My lord, I have challenged the bank. My lord, the borrower owed the bank 41 lakh of rupees. By selling, my lord,
borrower.
I am, my lord, the guarantor. Now, what happens is, my lord, by selling the property of the borrower, they get 38 lakhs. In spite of that, my lord, they put
waiver of pre-deposit.
No, no, no. Final sale. So then what they do, my lord, is sell off my property as well. Guarantor's property, in spite of the fact that only 3 lakhs was, my lord, required. We were not aware, my lord, of this sale at all. When we filed a writ petition in this honorable court, it's then, my lord, that the bank came up with an illegible sale certificate saying it's been sold. They've sold it for a few crores. They are now saying that I am keeping this money, whichever I had, the rest of the money you take away. This is fraud, my lord, on everybody.
Which is the order, where is the
Because
bank?
today, my lord, we are only on an injunction application that we filed. We feel, my lord, now the other person who's bought it, he's going to, my lord, encumber the property with tenants and things like that. So I'm only praying for, my lord, an injunction and allow me to serve, my lord, on the other side. Bank is served for us, sir. Bank
Caveat is there, Mr. Chatterjee.
Serve.
Who is for the caveator?
Nah.
But who is for the caveator?
Then keeps it tomorrow, my lord, in the supplementary list. Served upon them, service ta tha.
But have you given notice for upgradation? on there?
No, notice for upgradation.
Where is that? Where is the notice for upgradation?
And this is the, my lord, the service.
All right, keep it with you. কালকে রেখে দিন।
না কাল সকালবেলা থাকবে। Tomorrow in the morning, my lord.
Fixed matters. When it matters.
Look, after 2 o'clock tomorrow, I don't know what's going to happen.
Why?
হ্যাঁ গো, তোমরা দুটোর পর
এই শুনবেন না তো? Yes, yes.
Item number 1339.
কেন?
I'm opposing this application.
কোনদিন তোমাদের
I'm opposing this application.
Who is proposing? There is no one to.
I am proposing, my lord. I am seeking just a today one accommodation, my lord. I mean, some difficult. I didn't realize that the matter.
Traveling, Mr. Bose is traveling. It's a long weekend, Mr. Bose, for you. Is it a long weekend?
শুনতে পাচ্ছি না তো
Yes.
Well, may I file my affidavits, my lord, may be kept on record.
ওরা reply দেবে কিনা সেটা হচ্ছে প্রশ্ন।
Now, if they want to give a reply,
so he is for the petitioner.
Yes,
Yes,
ma'am.
Lordship, I am appearing. We'll just give a reply to this, Your Lordship. Well, kindly give us some time.
Not today, tomorrow it will appear.
But tomorrow I have some difficulty, my lord. I'm too difficulty. Let the affidavit option be kept on record. If they want to,
let it.
My lord, only one indulgence. My lord, they have filed the opposition, my lord.
He's
Allow me to file a reply. Allow me to file a reply and take it up any day convenient to your lordship.
They want to file it.
My lord, they have filed the opposition. Allow me to file a reply.
Because the monthly list will. So you can do one thing. I can record that. So you file your reply. Thereafter, you can mention thereafter because in the meantime the monthly list will come. What is the item number?
1339.
The affidavit in opposition
By
filed.
opposite party number 1.
What is the necessity of affidavit in opposition in a civil division application?
Lord, they insist that they want to file opposition.
Document facts suppress event, the application on the basis of which the order was passed impugned, that is also not annexed. What
The
can be
affidavit in
done?
opposition filed in court today is taken on record. Mr. Bose, learned senior advocate, appearing through virtual mode, prays for liberty to file a reply. Yes, Mr. Bose, how much time?
My lord, 10 days.
Prays
2 weeks, my lord, gives us a
2
fortnight.
weeks time to file the affidavit in reply. First up, let the affidavit in reply be filed within 2 weeks from date.
Affidavit to can 1 and also CO.
Let the matter appear after 3 weeks. Yes, call the next matter.
Maybe kept on.
Item number 1456.
1456, Your Lordship, I'm for the petitioner, Lordship.
1456, yes.
For the petitioner, Lordship, this is my affidavit service of the copy and also the affidavit service of the upgradation, Lordship.
Yes. Upgradation, there is a opposite party is there.
Yes, Your Lordship. Yes, Your Lordship.
What is the impugned order?
No, it's not a impugned order. It's for the expeditious disposal.
Expeditious
kindly,
disposal.
Lordship, give me 1 minute to show how the matter has been conducted. Kindly, if your Lordship could consider list of deaths.
But if there is the opposite party, I cannot take up in their absence.
Lordship, I have served them.
There is a 330 resolution, sir.
I have served them, Lordship. There is a yes.
The 330 resolution.
Fix that in tomorrow, Lordship. Tomorrow. 2 p.m. Lordship.
With regard to item number 116.
Not 2 p.m., 3 p.m.
3 p.m. With regard to item number 116 is.
You are not there.
I do not have any instructions to appear as well, Milord. Perhaps.
Then why have you mentioned?
I haven't mentioned, Milord.
Item number?
1166 perhaps, Milord.
1166 টা দিন তো।
1166
হ্যাঁ, যেটা এখানে ছিল 500 বার হলো না কি হলো? কয়েকটা আগে 1166 Your name was appearing, that was why I thought that.
No, Milord.
Say 1166. Imdadul Haq. He mentioned.
Yes, Milord. Milord, there is an opposite party as well, Milord. Yes, Milord. I have the instruction. Now I remember. Yes, Milord. Yes, Milord. If Milord kindly takes it up tomorrow, Milord. There is an opposite party. I have served him, Milord. Milord, if Milord kindly takes it up tomorrow, Milord, I shall. There is also a pen down tomorrow, Milord. Milord, if Milord kindly takes up tomorrow.
Today. Yes.